Hi guys, welcome. I'm testing my audio. How does it sound? I hope it sounds so perfect. Let me look in the chat. Hi, welcome. This is Kitchen Court Cases. I live for chaos. So like an hour and a half early, don't worry. Go. Just go, girl. You're good. Okay. Bubba. If Bubba wants to sponsor me ever, like Bubba, I'm gonna be the cheapest now that I'll ever be. And this mug has kept this coffee warm all day. It's now night, almost. It's evening. I'm giving you free advertising right now. Can you send me a turquoise one? I really like the robin's egg blue one. It's incredible. I don't know what the fuck they've done. Um, Let me hear what you've had for dinner tonight. Also do a med check. All the things we normally do. It's Friday. It's earlier than normal on my side of the world. You can see outside. It's bright and sunny out still, and it's only like 5 o'clock. So, also, I worked out today, you guys. I have my um, Fitbit. You can't really see whatever, and it's it's good. So, um, let's I'm not even going to just talk about the last one yet, Chris, because it deserves its own thing. As a woman who's given birth at that girl's age, as a woman who's been trained to teach people how to give birth, as a doula, as a just many things, there's so much wrong in that situation. As a person, here's my main point. I just said I wasn't going to talk about it, and now I'm talking about it. Here's my one point that has to be made. The failure is not with her. You have to understand something. It is great to vilify the person who was mentally ill or who was sick, who made the bad choice. But if you want to make the problem not happen again, how do we do that? We know we need to look like 3 steps back. So 2 weeks ago, she was in the hospital and you didn't do a fucking pregnancy test. And if you did do a pregnancy test and you counseled her and she pretended not to know what you're talking about or whatever, you didn't follow up with that. That is the failure. That was the intervention point. What strikes me is she called out for help twice. She went to the hospital. She went where we're taught to go for help. And her mother, did you notice when the first she got in her face and yelled at her? You know what? Fuck you, bitch. First of all, the doctor should not have done that at all in front of those people. She should have commanded that situation. This is my patient and she needs medical care right now. And that patient unfortunately has died, but this one I can save right now. And that should have been the first thing. And I'm sorry, that's not how you tell anybody their baby is dead, no matter what you think they did to make that baby die. That's just not the way it's done. The whole point. She might have Smoochie or Heather, but really, maybe she went to the hospital the first time and was just begging for somebody to take her the right way and give her the ability. Do you think somebody spoke to her at her last 2 weeks ago appointment at the emergency room and said, I want you to understand that if you have a baby that you don't want, there are laws that make it so that you can give that baby safely to somebody and will never tell anybody in your family ever. Do you think somebody said that to her? And do you think if they did explicitly weeks before that, she would have killed the baby? If then, yes. If that happened, then go ahead. Throw her in jail and lock the key. Lock away the key. But if that conversation wasn't had, because I don't think it was, if nobody went the extra mile to try and help her when she was there for help, I'm not saying no, sorry, Heather. Um, She would have done that at home, at school, at a gas station, wherever she wanted to. She didn't want her mom to know. But my point is that she might not have killed the baby if she had been told explicitly, there is a way for you to give birth secretly without us ever informing somebody about it. Sometimes you have to be literally like outright and clear. And I'm just reading the chat. I'm sorry. I'm not meaning to be rude to anybody or call anybody out. And you all know that I'm hard on people, but I was a 19-year-old mother. I was treated like shit in the hospital by a lot of people because of what they thought I would be like as a person or a mom at my age. And so what I'm saying is the way to prevent these things from happening is not to vilify her, unfortunately. It is to put aside the want to vilify her and to dig deep for the compassion to love her. That's my theory on it. And again, I think that it's babies dying is the worst thing. It sucks. It's horrible. But here's the thing. Was that in Canada? No. But you know what, Courtney? About, what was it, a month and a half ago, a month ago, there's a dead baby found in the parking lot right by my daughter's school. No mother to be found, not even in a hospital, in a parking lot in the dumpster, right down in my city, within sight of a fire station where she could have given the baby with no repercussions. My heart broke for the poor girl who wasn't getting the care she needed because she didn't even go to a hospital. And my heart broke in that video for that girl who was not being medically treated. If you assume that she just gave birth to a live baby, you need to clear that fucking room, do a pelvic exam, and make sure that she's delivered the placenta fully and that she's already started to contract her uterus and the bleeding is slowing. Ethically, that is your responsibility at that point, not to vilify her in front of 5 people about her dead baby that you didn't seem to care much about before. How did she get into a room in the hospital without having a pregnancy test first, yet left alone with her mother? Still not safe. She still ran. She came for help again, and nobody saw to say, oh, we need to separate this person and speak with them privately. You might think she knew she was pregnant, but you don't know that. There are truly people that do not have pregnancy awareness. There are truly people that grow up in households that have no sex ed and actually don't know that fucking results in babies. It's horrible, but that's the truth. And so, again, that's a failure that we can address really early on with sex education for people. And that's a failure we can address with talking about safe haven laws for people to give up babies with no repercussions to them. But with this particular case, I'm just heartbroken that the right person didn't intervene 2 weeks before when, I'm sorry, if you, by their standards, she was 8.5 months pregnant, they let her walk in and out with back pain and didn't think of pregnancy. Maybe she didn't know she was pregnant. If a fucking doctor didn't think she was pregnant at a hospital, right? My whole point is we're judging her based on her action at the end. Inexcusable. However, there was many intervention points being happening. I don't know, some law and crime video that was on Time Served. I apologize. It's some woman who committed infanticide. And that's the other thing. It may be you want to call it murder, but that's actually, there's a technical term for a woman who murders her child within the first year of life. It's infanticide. And so I believe even legally the charge is that. And they carry different different penalties, especially in Canada, that sentence can't be longer than 5 years because there's a there's just there's case law about it. I just happen to I know that it's a separate charge and it's based upon the age of the baby, etc. Again, I don't condone killing any babies. Like, obviously, you all know that about me. What I'm pissed about is the 15 trained professionals that she had to come into contact with that failed her. There's no way to put it otherwise. If you have a person who is at an advanced stage of pregnancy reporting to the emergency department and you don't verify their prenatal care and their gestational period, all of that, then that tells me they didn't present as pregnant at all. Not even a little bit to a doctor. That's pretty shocking to me. Again, I'm Canadian, but I've done more dip urine pregnancy tests. Every time you go to a clinic anywhere, they're like, can you give us some pee before you sit down? Like, literally, that's how it works. I've never sat in a bed before I've pissed on a pregnancy test. It's like a standard part of your workup. I don't understand why that wouldn't have been done, especially for abdominal or back pain. And again, you can be mad at her all you want, but do you want to be mad or do you want to actually prevent this from happening in the future from another person, another baby being killed? Because you could have stopped it. It could have easily been stopped. That requires a social worker visit if she's 8 months pregnant, 8.5 months pregnant, unable to acknowledge that. That's a social worker intervention. I thought your guys' system was, you know, like, to me, it's so obvious. And she went where she thought she could get help. That's the other heartbreaking part about it. She didn't go and again, again, many, many things. Um, so the biggest lesson to be taken away here and that you should pass on to anybody that you know, if you really don't want any dead babies and you think that people randomly, like, it's so whatever, but you can drop off in Canada and in the United States, in I think every state, there are safe haven laws. You can drop off a baby, no questions asked at fire departments without any penalty. Nobody's going to come looking for you. Nobody is going to try and tell on you. Nobody is going to be mad at you. They won't ask you for your name. They won't ask you for why you're doing it. They won't try and change your mind. You can go to a fire station. A lot of them have built-in baby boxes. You can go to a police station. You could go to a hospital. Generally, there's basically a period of amnesty for people that they need to know about. No questions asked. What happens is, as a person, if you drop a baby off in a baby box, there's another bag there. And you take that bag and you leave the baby. And in that bag, there's some information about what to do if you've just given birth, some resources and help if you choose to reach out for them, and a few other things that are necessary for somebody who may be in the biggest, I don't even know what to call it. I can't even imagine what despair you would be in. And again, I think that you really need to look at something if, again, like, no prenatal care versus like, what if, let's just hope, I really hope this is wrong, but what would happen if, like, she was raped by somebody and had no sex ed and didn't even know that she was raped? That was just the way she are worded. Whatever, daddy, YouTube daddy. This was supposed to be a fun night. Now I got ranting. Anyways, I guess the part that really bothered me the most is I gave birth to my daughter at 19 years old. The nurses treated me like absolute crap. They assumed that I didn't know how to do anything. They assumed that I didn't have a car seat. They assumed that I was some loser. And I mean, within 2 years, I was running a momming group with 500 moms doing a parenting spot on the news. But in the moment, at their mercy, I felt like nobody. I felt like worthless because the way that they just treated me. And that I'm a strong person. I am so strong. Oh man. You can't imagine. I mean, imagine if you're beaten down, if you can't, if you've already got a lot going on in your life, if you don't have people that love you, if you don't have a partner. I had so many things stacked for me, and yet I still felt like horrible when they treated me like this. And then now, you know, and I was like, not, I had nothing of her situation whatsoever, but yet they were able to impact me so significantly in a moment. That impact can be had the opposite way. And that's what people need to remember is that it's important to like be honest with your kids. If your daughter at 19 years old is so afraid to be acknowledging a pregnancy in front of you or like dealing with that, that's a big red flag to me. Like the interaction there was just crazy. Anyways, guys, I have amazing gold fucking court for tonight. Great stuff. You won't even believe it. Seriously. I love you all so much. What are you having for dinner? Yeah, boobies, I know. I'm still drinking from my Bubba cup. Oh, and to be clear, I'm all about like sex ed is so important for boys and girls and adults, actually. Funny enough, they don't know all of it. I love all of you guys, honestly, and know that even though I'm passionate about things, I'm passionate about a lot of things. Um, I'm never mad at anybody for their opinion, ever, 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 ever. Um, but I will passionately try and impart why I feel the way I do, probably. But I also accept new information, and I try and do. So Lucy's asked if I have any videos from when I did the mommy group. I think the news channel probably still has them because it was like on a weekly TV show where I did a parenting like spot. But they don't have, it was like in 2010. So, yeah, it was funny. I'll look for some. I think I would have to go and look them up. Um, like actually ask for them at the station is what I'm saying. Um, I am a great advocate for my opinion. I'm very loud. I'm going to probably be way louder than normal because Nana's away and she just gets so frowny faced when I'm get loud, but regardless. If you guys are new here, my name's Kitchen Court Cases. We watch court in my kitchen. This is a kitchen back here. Um, I watch court all the time. And this court hearing may be one of the top 5 that I've ever seen. Toby, oh my gosh. You guys are right. Hold on. We got to do some extra oh yeahs because God damn it, Larry. This was Larry's fault, okay? Handy P. Larry. But let's.
Oh, yeah.
And again.
Oh, yeah.
Let me go back and be super clear. Toby S., thank you so much. Thank God it's Friday, Toby says. What a great reminder to reset. we're going to reset and restart our show this evening. Oh, and Richard Harrison re-upping into the club. Um, like I said, seriously, like a unicorn frickin' thing. Charles, hi. Okay, Charles. Never mind. It might not be this. Let me just think of this. Let me just do what Orlando Chiquita. Oh my gosh. A daylight disinfectant. Oh yeah, oh yeah, oh yeah. Now, why is it should come up now because when it comes in the chat. If you're new here, we use that sort of porn sound for whenever somebody is so kind as to send a super chat to me. I appreciate them so much. Thank you, Donna. Thank you, Daylight. You guys know I love you so much. And Toby. And everybody. You guys, I love y'all.
Oh, yeah. Oh, yeah.
The layering has gotten a little bit messed up because of my I've just been trying to a few things, guys. Wendy, hello. Thank God it's Friday. Yes, V is for victory. Um, Charles had hospital roasted turkey with mac and cheese. I don't know what to think of. Well, you're saying hospital food, but I was thinking of a hospital roasted turkey, as in like they used hospital sort of. I don't know. I don't know. My brain's weird. Y'all know that. Okay. Yeah. Tommy, how is your channel doing? Um, you guys know that I love all my court people. This is why I barely get anything done. Tommy V and MI uh has a channel and it should be dropped in the chat shortly. 135. He's still doing and I still do this too. I don't want to admit how closely I watch, but I dance for subscribers. When I get subscribers, I totally dance. I love it. It's like a thrill. Anyways, Tommy V and MI has been hot off the presses with amazing stuff. He sent me stuff. I think you'll like this, Tommy. I think you'll like this one that we have for tonight. Um, this is, I'm going to let it play in its entirety because it is like a fine wine that gets better as you drink it. You are going to be thinking, is this judge serious? Seriously, I had a whole different title for the video in my mind, and then the hearing went on, and I'm like, this is insane. So, um, anyways, I have so much. We'll be here a long time tonight. This is for all you stamina people. Also, I see you all. Happy Friday. Um, uh-oh, Lucy. We want to hear about it. That's not good. So my phone's going, oh my God. Just play the video.
Good afternoon, everybody. Close this out.
Judge, wait.
Oop.
Whoa. 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 Hold on. I have to set the seat. The thing is that when I started watching this, the judge is somebody new. He's a pro tem. We know what that means, which means temporary. And it is in Thurston. And this is the civil motions and vehicle impound docket. Oh, juicy. So, um, we're going to watch him first seem to think that they're not on the Zoom call, but They are, as far as I can tell. And also, I'm just going to pre-warn you, there is a hot cop that is going to be appearing in this call. Actually, he's there already. You can't see him, but fuck. It's almost like I planned it. Seriously, watch what happens when I pull this screen out to the right size. Literally, it's like you'd almost think that I knew what I was doing. Look at this guy. Hi. So we are going to be, what have I done to this screen? Actually, we need to sort that out. But anyway, so to set the mood, I'll let it play while I'm fixing it. Also hit the like button, please. I don't know how to make YouTube Daddy like me the more.
Did I do something bad? Hold on. I think I accidentally signed out.
1 second.
You didn't have to see it.
No, that's okay. And then I'm gonna ask to join her audio.
That's what I did wrong. Say no when it says audio?
Just click the X actually.
Okay.
Just at the X again. Again.
No, so it comes back to this.
Here. Okay. Join the meeting.
Okay.
It's the 6-5.
To be clear, I just admire him being just put together. I think maybe it's the camera quality, I don't know, but like no. He's not really my type either. I just think he's cute. But no. I don't think he could handle it.
3 359 1636.
Okay.
Join.
And you don't want me to check, don't connect to audio or any of that stuff?
Yeah.
So just, let them go. Join.
Also, if I can get somebody to be on the lookout for vaping, not my square either. I want timestamps of the vapes.
So it does that. And then we come here. Mhm.
Okay, so click the X on that.
We don't want to join with computer audio?
No.
Oh, because we're using a different audio system.
And then just press continue.
Ah. There we go. Sorry about that, everybody. We were getting, for some reason, we kept getting punted out of the meeting. I assume, is it Officer Girkman?
Yes, sir.
Are you here for the impound case?
Yes, I am, sir.
Okay. Do we have everybody else here? Because I'd like to, if possible, we have somebody here from South Sound Towing or representing South Sound Towing. Good morning. I'd like to go ahead and do that one so we can first, even though it's, I think, 4th on our docket, so we can get the officer back out on the road. Let me just look at something right quick.
Let me look
Do
at something
we
right quick too. I'm
have
trying to boost
Sean
the volume.
Cruz or somebody representing Sean Cruz? Okay, Sean Cruz was the petitioner in this case. Seeing how he's not.
Remember the name Sean Cruz. Sean Cruz is gonna fucking Tom Cruise his way into this case in about, I would say 18 minutes. You guys have not met Mr. Cruz or anybody really like him before. I'm gonna believe that. I'm trying to boost the audio. Just give me 1 sec. I also have 57 windows open, which is just not really helpful. It's part of ADD.
Present. My assumption is we just dismissed the petition, right?
No, the hearing is set actually at 2 o'clock.
That's right. No, the Jays just brought up a good point, which, what? Oh, did he call and say he couldn't be here?
It was at 1:30 today.
Yeah.
They're normally scheduled at 2.
Yeah, I see that it's listed at 2 on the docket, but I saw when I looked at the schedule yesterday, it was. Do we know, what is it? I think the notice to Mr. Cruz said 1:30, right? Here's what I'm gonna do. It's 1:35 now. Officer, if it's all right with you, I'd like to give Mr. Cruz like 5 more minutes to show up before we move on or before we dismiss this petition and move on. Is that okay with you from South Santongo as well?
Yes.
Okay, I just wanted to check. We want to give them every opportunity we can. Who else do we have? Do we have any matched pairs? I assume not. Who's here on? Oh, go ahead, sir. Mr. Case.
Oh, I don't know, Your Honor. I'm here on Peterson Enterprises versus Kristen Cole.
Okay. And Mr. Jacobson, who are you here on?
Your Honor, I here representing Citibank versus Nicholas Robinson.
Okay. And then how about you, Miss Nguyen?
Good afternoon, Your Honor. I'm here on Physicians and Dentists Credit Bureau versus Saeed Alawi.
Okay. And is it the defendants are both Saeed Alawi and Ahmadi Saad, correct?
And Ahmadi. Yes, correct, Your Honor.
Okay. Between the three of you.
Okay. So sorry. I'm just this is the part, it's gonna be the first part of this video. I literally thought the judge was an imposter. Like, listen to some of the questions he begins to ask, and he sounds like a sob sit. I'm not even joking. This is it. I literally, at the beginning, this whole video was going to be about this judge, and Mr. Cruz comes later. But this judge and his questions, seriously, I want to hear your thoughts on it. Guys, also, I love you all, and I thought you would really enjoy the call. I know you guys. Also, I'm looking for better audio because you know me, I love you and I care. But let's keep going and listen to what the judge says to this lawyer once they decide who goes first. Also, there's this lawyer down here, bottom right, Mark Case. Case, really? Lawyer?
Is there any one of the three of you has a burning need to get out of here right away, such that it would make sense to move you to the front of the line? Otherwise, I'll just go top to bottom on the docket if that's okay.
Very good, Your Honor.
So
That's fine with me, Your
we'll
Honor.
okay, good. Thank you so much. We'll start out with cause number 129265 CV. Thank you very much. Which is Physicians and Dentists Credit Bureau versus Saeed Alawi and Soad Ahmadi. I'm probably mispronouncing that. This is a request for summary judgment on what appears to be a debtor-creditor issue. I am less familiar, I'm sure, than you with debtor-creditor because I've done so very little of it in my career. I guess the only question sort of I had, and this is not your fault, this is my unfamiliarity with this subject matter. Is this a statutory or common law cause of action? Do we know?
It's statutory because
Okay.
it's.
Do you happen to know the statute citation? Because it wasn't, like I said, it's my unfamiliarity with the subject matter. There's one thing I want to, go ahead.
Yeah, so it's the CRLJ 56 for motion for summary judgment, and we were required to serve the defendant with our motion and with a copy of the rule so that they're aware of how to reply and how to respond to a motion for summary judgment. And we have a declaration of service which we served on March 30th, and we filed that with the court.
And is the underlying cause of action, like is it a statutory debtor collector cause of action? Is it a common law one like money due and owing or contract? Or where does the sort of the legal cause of action stem from? That was my question.
Yeah, so it's a contract base. So it's a breach of contract and an unjust enrichment claim analysis. The Physicians and Dentists Credit Bureau is an assignee of the debt. So this is a medical debt from a doctor's office. They render the services to the defendant. The defendants fail to pay for the said services, and so essentially it's a breach of contract, because they sign a contract saying that they'll be on the line responsible for those services, and then obviously unjust enrichment, because then they're enriched by the service and fail to pay.
Very good. And it looks like the total amount is $4,055.05. Is that as of today with all the prejudgment interest? Or that's the amount you're praying for today, correct?
That's the amount we're praying for. We'll stay with that amount. That's fine.
Okay. And do we have any, Madam Clerk,
Whoa, missed that one the first time. Let's start counting. This is the first of many weird phrases this judge is going to say today that I've never heard other judges say. This one being, is that what you're praying for? Okay. It's just an odd way of putting that. This just honestly, it gets better and better by the moment. The attorney is like, you want me to explain what to you, sir?
did we receive anything from either the two defendants, Soad or Alawi? We're gonna just check to make sure that they haven't already reached out to the court and said they couldn't be here.
Sure.
Okay. So I'll note that they did not appear. Thank you very much. Okay, I've reviewed all the pleadings in this case prior to taking the bench. I'm intimately familiar with Rule 56 and how summary judgment works. I'm an assistant attorney general. I've represented the state and probably filed a bajillion of them myself. Probably not as many as you have, given the
Bajillion? Sorry, what? And why does the record need that?
quantity of work that you do in this arena. I find that the record does substantiate a claim for both unjust enrichment and money due and owing, and kind of a breach of contract claim, although that wasn't as clear. Summary judgment was properly filed. It was served. I have no reason to believe that they did not receive personal service. We haven't received any communication from the defendants. And so the only record I have in front of me is that which, Ms. Nguyen, you created, which I believe is a matter of right. You are entitled to judgment in the amount of $4,055.05. And I'll sign the order, the proposed order that you submitted along with your motion.
All right. Thank you, Your Honor. And
Yeah.
that is all
From
I
your
have.
perspective- Pardon?
Yes. No,
Oh,
please
was there
go ahead.
anything I was gonna say, is there anything I missed or left out?
No, that covers everything, Your Honor.
Okay, very good. You're free to go.
Thank you. Thank you. Have a good weekend.
You do. Why don't we quickly do Citibank versus Nicholas Filer?
Your Honor, Nicola Filer is the attorney from Satella and Hammer that probably filed the lawsuit, but it's Nicholas Robinson is the defendant.
Oh, sorry, right. I was looking at the wrong line. Is he still represented, do you know, by Peter Schneider?
In my database, he is, and Mr. Schneider did file a motion for continuance back in April when this was first noted. But let me check one more time. I haven't received any communication from him regarding this action since that motion to continue.
Remember, these are civil matters, so there's no. The failure to appear usually works out better.
Right, and then it was continued from April 21st, 2023 to today's date.
Yes.
In looking at the court file, I didn't see a response on the summary judgment. Did you?
No, Your Honor, we haven't received a response on the summary
Do you
judgment.
have the order? Oh. Okay, this is Citibank versus Nicholas Robinson. It's cause number 134781. Plaintiffs are present through their attorney, John Jacobson, who's appearing via Zoom. The defendants are not present. Did we receive any communication from Mr. Robinson, which would explain or justify his non-presence, or from his attorney? Okay. Obviously, Mr. Robinson has been previously served, has appeared, filed a motion back in April to continue the case to today's date. I have no reason to believe that either he or his attorney didn't receive notice of the rescheduled date. I have reviewed all the pleadings. Thanks to Ms. Nguyen kind of educating me on debtor collector, I have a better feel for what we're doing today and why. Is there anything, Mr. Jacobson, that you want to add?
No, Your Honor, it's all in the file, just that we did send Mr. Schneider, the opposing counsel, notice of this hearing on April 28th, when the court instructed us to renote the hearing, since he wasn't at the previous hearing either. And I communicate with him a lot, but he hasn't communicated with me regarding this particular matter. So
Okay.
we believe we're entitled to judgment.
Yep. Okay, today is
Did something happen to Streamy? No, I can't have that. Oh, fuck, did I press a button wrong? I really hope I didn't. Oh, you guys would freak out. Let's continue. As usual, most of what court is paperwork and making sure that you got the right paperwork. And that becomes critically important very, very soon in this case. I'll work on Streamy, I'm sorry, just give me a couple minutes.
June 2nd, 2023. So I'll date the order this 7th day of June. Okay. I signed your order. Thank you very much for being here today. I appreciate it.
Thank you, Your Honor. Have a good weekend.
You bet. Let's go ahead and do our impound case right quick, so we can get the officer back on the road and get our friends from South Sound Towing back to work as well. Okay, this is cause number VH23-0013. It's the vehicle impound. I call them appeals, but it's a vehicle impound hearing requested by the owner of the vehicle that was impounded.
Hold on. Oh, you guys can't quite hear it. Listen carefully. There's an ice cream truck outside that just seriously distracted me. Do not go outside for ice cream. Do not. Seriously, there's an ice cream. I'm serious. Oh my god. It's getting loud. I'll keep going. Can you hear it? First of all, I don't think that's the ice cream song, but apparently it works.
Sean Cruz, present on the platform is Officer Joseph Gerkman. From which department are you with?
Lacey Police Department, Your Honor.
Lacey PD, also present. Looks like I have two representatives from South Sound Towing. Can you please state your names? Petition.
Sorry, we have to just hone in on something here. I have to. What the fuck is going on with the lighting? Wow. Okay. I have to fix that. But this gentleman here, this police officer, thank you, sir, for your service. Thank you, first of all. I know it's a hard job, and I'm not trying to make fun of it at all. But his last name is Jerkman. Okay? He's probably pretty happy he's good looking, because it would be a tough last name. That's almost like the one, what was the one in the last thing? Werbanger or something like that. Anyways. Okay. He is well groomed. That's what I really like. It looks like he does his eyebrows like way more than I do mine.
I'm Sierra Deal.
Nicholas Holter.
Very good. Good afternoon, both of you.
Thank you.
This matter was, I was looking in the file last night when the notice for hearing went out to all involved. It did say 1:30. It's about.
Oh, I think I stopped And then I heard the ice cream. This is crucial. What happens right now for what transpires later. And again, just is very crucial. So pay attention to when they're talking about what time this hearing was supposed to be.
About 1:45 now. I was looking in the file last night when the notice for hearing went out to all involved. It did say 1:30. It's about 1:45 now. I don't see Mr. Cruz present either on the platform. There is, as they say, nobody in here but us chickens. So we'll go ahead and dismiss the petition for review for the petitioner's non-appearance. Thank you all for your patience this afternoon. I appreciate it.
Thank you, Your Honor.
Yeah, take care. All right, Mr. Case, it's the Mr. Case show now. This is Peterson Enterprises versus Kristen Cole. It's cause number 136750. Present on behalf of the plaintiffs in this case is Attorney Mark Case. I don't see either the defendants or anyone appearing on their behalf. Do we have anything to suggest that they reached out to the court to say why they weren't going to be here today? Sorry, let me just check one thing right quick. Okay, we haven't received any notice. Mr. Case, have you heard from the defendants at all for any reason why they might not be here today?
No, Your Honor, we have not.
They've been proceeding pro se this, or Miss Cole hasn't, nobody has appeared on her behalf in this case, as far as I saw, right?
That's correct. Yes, she was acting pro se.
Okay. Let me just see who this is. There's somebody connecting now via Samsung.
Oh, yes, there is. This, oh, Charles, don't leave. This is it.
They're still connecting, sorry.
Yeah, I know. I can see it.
Oh, okay, good. I wasn't sure what you can see versus what I can.
I think Charles did quote NSYNC, but I was just making sure he doesn't go bye, bye, bye.
It looks like we have somebody join the platform. What my screen shows is Samsung SMS1. Can you please identify yourself? Pardon? Oh, okay. Let me just, it looks like what the clerk's indicating is that person, whoever's trying to sign in, maybe having problems connecting with audio. So let me just give them a second. If you can hear me, whoever's on the phone under Samsung SM, if that is a phone, I think it's *6 to mute and unmute, correct? Yeah. So you might try that. And if you're able to unmute, please sing out so we know you're there.
He is going to regret that.
These are huh. Okay. Sounds like we have somebody on who's it says Samsung SMS1. Who are you? Who is this?
Hello?
Hello?
I'm not familiar with this beast. Yeah.
Hi, this is Pro Tem District Court Judge Andrew Lagerwell. Who am I speaking to?
Sean Cruz.
Ah. Okay, Mr. Cruz, here's what happened. Let me just check one thing while I'm thinking about it. Can I get into Do you have the file, the actual paper file, or can I get in this where I can see all the pleadings and stuff?
You should
Shit's
be
from
able
over
to click on the case number. up
Right
there, it
here?
Should pop up.
Ah.
There, and it'll pop up in just a second and everything that's in the file. will-
Okay. Sorry, Mr. Case, this should just take a minute.
Not a problem, Judge. Thank you.
So, Mr. Cruz, the notice of civil hearing indicated the hearing was supposed to be at 1:30. We waited for about 15 minutes. We had an officer and the folks from South Sound were all present on the platform. Because you weren't here and we had waited, I ended up dismissing the petition and excusing the officer and the South Sound towing folks from being here. Let me just check with my clerk before I say much else.
Yeah, mine says 2 o'clock right here.
Notice of civil hearing that I have says 1:30.
Yeah, we didn't get
but
notice.
let me-
We just wrote it on the thing. It says 6/2/23 at 2 p.m.
So I've got 3 different notices. They went out to you, to South Sound Towing, and to the
Those ones
officer.
were mailed.
These-
Those ones were mailed to them.
Yeah, that were all mailed and none of them were returned. Do we have one? I mean,
Yeah,
I know the
fucking
docket
thanks, dude.
had it listed potentially too, but do we have
You got
anything
an
that
app that
shows?
says what we got, right?
On an email I can't get into since my phone is.
Hold on, we're just checking our files.
Cost me a fucking car.
I can't get into that email. Otherwise, we would know.
I asked you to do one thing, you can't do it.
Pardon?
Oh, no, I'm sorry. I was talking to somebody else.
Oh, okay. No worries.
I forget. I'm not familiar with these things, man. Look, I've been in prison 25 years. I don't know how to use the phone. I don't know how to use anything. I'm pretty much an idiot. But I had to rely on someone to get me on this thing, and I just now got on it. And that same
Yeah.
person wrote down 6/2/23 at 2 p.m. was what we were told. It's written on this thing right here. Sir, I'm sorry. In prison we don't get the privilege of using phones or Connects or Zoom
Yeah.
or any of that stuff. So I don't know how to get onto this stuff. You know what I mean?
I
And
hear you.
I don't have a car, so I would have made it there in person, but they took my car. You know, the thieves stole it, and then these guys took it from them, and then they want to charge me because these idiots stole my vehicle. You know, and then
Yeah,
apparently
no, I
the
hear
thieves
you.
only got a ticket for $800, but these guys want to charge me $3,000 just to get my car back.
Yeah, hold on. I'm just trying to check something.
Yes, sir.
Yeah. Do you know why he had notices for 2? I mean, it was sort of on the docket that way.
I'm gonna start stealing fucking cars.
Yeah.
Well, it's done.
We're gonna re-rack that one.
Yeah, hold on. I'm just trying to check something.
Yes, sir.
Yeah. Do you know why he had notices for 2? I mean, it was sort of on the docket that way.
I'm gonna start stealing fucking cars.
Yeah.
Well, it's done.
I'm just gonna have to start stealing fucking cars, he says.
So. Do we just have
He's
him-
sounds abusive too. He's about to tell her to get the fuck out, by the way.
He is the petitioner in the impound case. Yeah, it's the petitioner.
Also, keep in mind the judge
Hey,
has
Senator, you can
dismissed
get
this
the fuck out of the
case.
house too.
Yeah, no worries. Everybody else was here at 1:30. Yeah, it's the petitioner. Correct.
Hey, Senator, you can get the fuck out of the house too.
Yeah, no worries. Everybody else was here at 1:30. We waited about 15-20 minutes. We had an officer who's sitting in his car on the side of the road.
Oh, okay. I'm tracking that.
Yeah, so I ended up just saying, well, you know, the notice that went out to all the parties said 1:30. And so. I don't know.
Man, fuck this, man. Fucking $16,000 fucking car. They think they're just gonna steal my car? Yeah, right.
So do we just maybe just renote it and reissue? Yeah. So, Mr. Cruz, are you still there?
Yeah, I'm still here for now, yeah.
Oh, okay, here's what we're gonna do. We've got two different, so the notice for hearing that I can see in the system, the actual one that went out, shows 1:30. There's an indication in our computer system that notice may have also gone out that said 2 p.m. Right. So here's what I'm gonna do. I don't want to dismiss your petition because you did follow to the best of your ability, apparently.
He already did dismiss his petition, Your Honor. And I am sorry, but okay, I was watching this live. Like I said, I had the first part of this video like, oh, this judge sounds like a sov sit. He's asking all these questions. He's sort of bumbling around. And I just kept listening. And then it became like serious. Like, this is a domestic situation that's happening here. And the judge doesn't even seem to be noticing. He has no notice that I think the lawyer hears this going on. I mean, how can you not? I hear it. I was like, this guy on, oh my God. And then turns out the hearing time is ambiguous enough that they are going to have to revert that decision. But this is when I'm really upset that a judge like Judge Middleton isn't on the case, because he would have been on that, like, you know, like a lot, very fast. Because again, this is a like red flag opportunity. There's so many things happening here that just sound like off and crazy, and it gets worse. It's not even done yet, y'all. It gets worse. But what I want to point out is, if what Judge Middleton probably would have done was, or sorry, I apologize. Well, no, I think what Judge Middleton would have done is called back the lawyer, all the people. He would have just called them back and made them come back on the phone. And he wouldn't have talked with the guy without him being there. He would have explained, hey, this is an ex parte discussion. I'm not to discuss any parts of this case with you. And maybe the caveat there is that it was a dismissed case moments ago, but now he's just said, I'm not dismissing the case. But this is completely done ex parte, or I guess, what is it called when the judge does it in their thing? Pro tem? No, that means temporary. You guys know what I mean. The Latin term for when the judge makes their own motion. Sua sponte. Sua sponte. Anyways, okay. So, but yeah, I don't think that, I think Manning would have sent officers to his door to deal with it. I think Judge Middleton would have called the people back in to have the hearing there and then and dealt with it. I think that many other judges we've seen would have dealt with this very, very differently. We saw some serious red flags right there that are concerning to me. I was like worried. I was like, shit, am I gonna why am I seeming like the most concerned person here when there's a judge and a lawyer who seemingly can hear this as well? The judge just seems like he's literally living in his own world. I don't know.
Notice that was sent to you, although, like I said, until I looked into this different computer system that we have other than the actual hard copy file. So what I'd like to do is I'd like to just renote this for a hearing, so you do have an opportunity to contest the impound. And this time we'll make sure that the proper notice goes out to everybody. So you'll still have an opportunity
Yeah.
to
Sir,
appeal the
I'm sorry.
account and potentially get your money back. Okay,
Yeah, sir, may I point something out, please?
please.
I appreciate you being fair and reasonable because that's very, very, very seldom found in this society today, especially in my life. But I lost my job because I don't have a car. You know, I have a pregnant girlfriend that can't go to appointments. You know, and this is my problems, not yours, and this ain't the Tony's problems. But you know, the thieves that stole my car, they got no problem going to work because they go out and steal my car. You know, they benefited 100% from this. The guy got an $800 ticket and stole my stereo, which is worth $5,000. You know, I'm being punished for trying to do the right thing here. It just, I know it just woes me, but man, this really sucks because I don't have a job now. You know, I can't pay the towing fee because they took my car. You know, and I didn't drive the car. You know, the thieves drove the car. And they don't have to get punished. You know what I mean? It just seems like something's wrong here. It seems insane to me. You know, and I know these are my problems, not you guys', and I'll deal with it the best I can. But man, it just seems like backwards to me that the criminals in this case are just getting off and actually benefiting from all this. You know, and I'm being
no,
punished.
that's an understandable frustration for sure. You know, I am constrained in my position by what the statutes say and what the law allows and doesn't allow. And without the other side present, I can't grant your petition, but I can give you another shot at it. So because it appears that the court set out inconsistent notices of when the hearing was going to be here. Okay.
Okay. All right. I appreciate that. How soon will this be? Because I really need my car back, man. Now I got to find another job.
Oh, they're always on Friday. Yeah, and the 16th is before the long weekend.
Oh, wait, no, sorry.
Can we do it the 9th? Is there any way?
We can, it's, give me 1 second, let me find out what day.
So here's what we're gonna do. We'll set it for as soon as the court can hear it. And then you should receive notice by Tuesday-ish of next week. But we have to check to make sure that we've got a schedule that's open so that we can slot your case in, okay?
Yeah, sir, I appreciate that. And I'm not trying to be unpleasant, but sir, I lost my job. I can't afford to pay my bills. You know, I don't have a car, I don't have a vehicle. And it just seems like the criminals are making out on the best on this. I even offered to pay the towing guys the $700 because I don't think they should work for free. I don't think I should pay it, but they want me to pay $3,000. I don't have $3,000, you know, I don't have a car. You know, and I know it just seems like it seems insane to me. You know, I'm trying to live right and do the right thing, man. I did my whole life in prison. You know, I don't want to do no more prison time. But it seems like these days the criminals are.
Yeah, I mean, I agree with what I'm going to interpret as sort of one of the underlying points you're making is there is a real disconnect between the criminal justice system and the civil system at times. Do you know, have they been able to figure out who took your car?
Oh my God, the disconnect, Judge, I believe is with you. He is really not concerned about the disconnect between the civil and the judicial systems. That is not his concern. Oh my.
Oh, he's muted now.
No. Amy, he was in prison for 25 years, so he must be 40 plus. He said he did 25 years, most of his life in prison, doesn't know how to use the phone, and has a $5,000 stereo. My life is a stereo.
He might have muted it on his end. Mr. Cruz, I appreciate your thoughts and comments, and I appreciate you being here today. And to the extent that the confusion was caused by different court notices that went out. Okay. Looks like the earliest we could reset it, unfortunately, is for the 16th, but we can reset it for then. So you should receive notice in the mail, and it will be the 16th at 2 p.m., correct? Okay. And he's gone. Okay, Mr. Case, sorry about that. Well, not sorry, but thank you for your patience.
Oh, you bet, Your Honor.
I did have an opportunity to review all the pleadings last night. It does appear that there are adequate facts in the record, and that you're entitled to judgment as a matter of law in the amount of $949.36. Today is the 2nd of June. We don't have anything to indicate that we've received any contact from the defendant saying they can't be here for any reason.
Also, I believe if you were a defendant in any of the cases today that didn't show up, wouldn't you have some precedent to, or some standing to be like, the notices were wrong that day? Like, how come you're sure that everybody else, nobody showed up? Sounds like all the, anyways. Let's get to the next case, guys. If you're new here, you can go ahead and hit that like button or the dislike button, like whichever you prefer. I'm Kitchen Court Cases. We watch court in my kitchen. We are moving through some of the stuff that I got today and yesterday. That was good. That was really, really good. We also have, yes, let me play one more short one before we get into a more long clip for a little bit of shoot. So, where was it? That's a question. What's the date? Is it the 2nd? I'm confused why I already have the 3rd. Oh, the date's different. Okay. Videos, that's why. Okay, sorry guys. I'm all thrown off getting started so early. That cop was pretty cute though, wasn't he? I don't think I labeled that one, but that's okay. I will find it anyway. Okay. Let's just go with this one.
Up before I move on to the, oh, nope, still one more on my 2 o'clock calendar. Before I move on to the 2:30s, do I have a Veronica Zavala?
Yes, I'm right here.
Did you hear my introductory remarks?
Yes, I did.
Okay, how do you?
This is not the one I'm talking about. We watched this yesterday. Hold on. That was yesterday. I need today. Dang it, Bobby. It was this day. It was the same judge. It's just
The judge who was supposed.
he gives the most, I think, perfect introduction to civil cases that I've ever heard, and I think probably should be mandatory for people to listen to.
Supposed to be with us. The judge who was supposed to be with us to apologize for being a couple minutes late. The judge who was supposed to be with us this morning is home with a sick child, which means the judge who prepared and read everyone's documents, if they supplied any, is not here. I will do the best I can with knowing absolutely nothing about any of your cases. And so this may take a little longer than normal. I see we do have dispute resolution with us. Okay, on to my introductory remarks. Good morning, everyone. Looks like is there service on all of these? That's okay. At the moment, it looks like we have 7 cases on for today. Since I didn't prepare for the calendar, I don't know if we have service on all of those or not. But here's how we're going to proceed on these cases. When I call your case, if you're in person, you'll step up to the tables. If you are on Zoom, stay right where you are. I will swear both sides in, and first I'll hear from the plaintiff, the one who brought the complaint, and then I'll hear from the defendant, the one who is defending against the complaint, and I'll decide the case. I will decide based on the facts as I hear them and on the law. Now, for the next few minutes, I'm going to explain why that is important. If you choose to go to a small claims trial, which is what this will be when I swear you in, you are giving up the best chance that you have to reach a resolution that might result in the best solution to the problem. When you go to trial, you aren't asking me to come up with the best solution. You are asking me to come up with the legally correct solution. I can assure you, in many instances, the legally correct solution is not the best solution. In many instances, the legally correct solution, in most instances, the legally correct solution is not what I might look and say is the best solution for everyone. You'll come up, I will listen to your testimony, and it may appear to me that there is a very obvious way to solve the issue. That way might meet the needs of both parties. But I'm not going to be able to solve it that way because I have to go with the legally correct answer. And almost certainly, that means I'm going to be ignoring the best solution just to choose what is legally correct. If you go to trial, you're turning the matter over to me and I'm going to solve it. But you're not going to have any say in how I choose to solve it. That is a distinct limitation in turning it over to me and asking me to solve it. And there's another limitation in that I know absolutely nothing about the problem that brings you here today. In fact, normally the judge would have at least reviewed the pleadings, the evidence, if any, was supplied. I haven't done that this morning. All I am going to know is what you tell me and what I can review during the trial. If it's maybe an apartment rental or a house, remember, I haven't seen that house or apartment. I don't know what condition it was in when you moved in. I don't know whether you were good tenants or bad tenants. I don't know if you made a good effort to clean up when you left or whether you just left. If it's a contract, and particularly if that contract is not set forth completely in writing and the two of you have some dispute as to what the terms are, You are each going to come up here and tell me what you believe you agreed after what I assume will be some pretty lengthy discussions. Then you're going to ask me what the terms of the contract are, knowing that I was not a party to that contract. I didn't hear those discussions. And if I decide, well, I can guarantee one side is not going to like whatever decision I come up with there, because I'm going to decide it based on the facts as I find them and the law, not what I think might be a good solution. If it's a car accident, I didn't see it happen. I wasn't there. There's no video, almost certainly. If there is, you probably wouldn't wind up in here. So what you're going to do is you're each going to come up here, you're going to point the finger at the other side, you're going to tell me it's all their fault, and I'll have to make a decision. So anytime you go to trial, your versions are going to be completely different, because you're going to be telling me what happened from your perspective. That doesn't mean the other side is not being truthful. It does mean they are seeing it differently. It might mean that. But that's normal. That's what people do. And I still have to decide which one is correct. Now, some of you may be telling me different versions because you're choosing not to tell me the truth. And you're asking me to figure that out. You're going to ask me to figure out, knowing that I don't know either side. I don't have any ability to sit here, listen to your testimony, and think to myself while listening to your testimony that, well, I've known this person for a long time. I've always known them to be accurate, never exaggerate. And I can't sit here and think the opposite. So I don't have any ability to sit here, listen to the testimony, and compare what I'm hearing to facts that I know.
Do you remember what I said at the start? I think this should be a prerequisite for litigants. Because imagine how much BS this guy has been through to make this his speech. I mean, Judge Kim, I'm going to write that down. But seriously. Also, this is Washington again. Secondly, I don't know if he's always like this. I sub to like 600 court channels. I just love different courts. I love it. Because every time you learn a little bit of something new, like they do review the paperwork first, but apparently they don't need to, because Buddy's pinch hitting here and he's putting that on the record, and it doesn't seem to be a bother. She's literally like, sir. And actually that lady is the dispute resolution lady. She's like, oh my God. But he might literally lull some people into doing dispute resolution who otherwise, you can not listen to somebody for so long. He's the cadence of his words, and they're simple. He's using explanations that average people can understand. He's ticking off things of this is what you're going to tell me. And everyone's just like, oh shit, that is what I was going to tell him. Every judge has this spiel for different types of hearings that they do. Some of them are more elaborate, some of them are less. This guy could speak faster, that's the truth. And are you talking about me, my Moderna? Okay. Also, look at Dr. Foley, first of all. Fucking flexing. Like, do you want to know a flex? I have 14 degrees on my wall, and when I go on Zoom court, I just leave it fucking pointed at my degrees. Like, if you're gonna spend the amount of money that a doctor spends to get degrees, I absolutely would make that my Zoom background. It would be my wedding photo background, everything. Make it into t-shirts. Fuck yeah. You go, Dr. Foley.
You may be sitting there listening to the other party testify, and they may say something that you know certain things, and you think to yourself, I can't believe they just said that. Well, fair warning,
That lady, the only other lady other than me, is the mediator. If we can see there, her name is Marnie, and it says DRC. You probably can't see it, but it says DRC mediator. Hold on. I swear it does. Anyways, it's how many diplomas? Count them. 14, 2. There's this heart. I like the heart, whatever this heart. I like these heart. You know what I'm talking about. It blocks one fucking word every time. And it's always a critical word when I'm looking in the chat. It's like Richard said, okay, CC, actually it's, and then it blocked the number. It's like, meh. If YouTube Daddy's listening, move that heart into the middle of the fucking thing where your thumb is anyways so that people can hit it easier.
I won't know if what they said is an exaggeration or even an outright lie. Sometimes it's obvious. Sometimes it's not. I might actually believe what the other side is saying. And if I believe it, you're probably not going to like the outcome I reach. Now, you took the time to come here today because you all, both sides, you all know that you are right. And the nature of the process here is that I'm going to tell half of you, and maybe more, that you are wrong. That's because I'm going to have to decide the case in favor of one side or the other. So as you sit here right now, your odds are at best 50-50 that I'm going to rule in your favor. And I don't think they're even that good. The reason that I don't think they're that good is even if you prevail, even if I determine that you're entitled to a judgment, I might decide that you are entitled to a judgment for one heck of a lot less than you thought you were entitled to. In the end, it might even be so little money that you question the wisdom of taking your time to come in here to resolve the problem.
Thurston County.
You might be sitting there saying afterward, you know, I can't believe I sat there all morning long after waiting 3 months or whatever to get a court date. And all I have to show for my efforts are this piece of paper. And then getting that piece of paper isn't even the end. Because even if I decide in your favor and issue a judgment, that's all you have is a piece of paper. Unless you know right now how to get money on a judgment, you might be in for the more difficult part of the process. getting satisfaction on a judgment can be very difficult. And the court can't tell you how to do that. We aren't allowed to give you legal advice. So now you may be a veteran of the legal system. Maybe you've been through this process many times and you know what it takes to enforce a small claims judgment, and that's fine. You can go about taking the steps necessary to enforce that. But for most of you, that's not going to be the case. This is probably your first, and for most of you, you hope, only time in a courtroom. And you don't have a clue what you're supposed to do with that piece of paper. It's really aggravating for you then when I have to say, I'm sorry, I can't tell you what to do with it. What do you do when you want legal advice? Well, you go talk to an attorney. There are lots of attorneys here in town and they'll be happy to talk to you. They will also be happy to charge you to keep talking to you. In many cases, if that's what you need to do, you might end up paying more in attorney's fees than what you recover on the judgment. Our statistics show that you are much more likely to recover on the resolution to the problem if you achieve that resolution through a negotiated solution rather than walking out of here with that piece of paper I was talking about. Now, in just a moment here, I'm going to call through the calendar. I'm going to see who we have on one or both sides. And then I will turn it over to our dispute resolution folks. I'm going to have dispute resolution meet with both sides in a case and see if we can't work out the best solution one thing I ask is that you at least give dispute resolution a fair try at resolving this. Because if you don't, I will be deciding it, and I will decide it, and at least half of you are going to go home unhappy. So give dispute resolution an honest, legitimate chance.
Billy Elliot, I gotta say something to you. I found out that Iron Brew in Scotland has changed the recipe, and did we talk about this already? Nana wrote a letter to Iron Brew. I fucking wish I had a copy of that letter. For some reason, my Nana, you guys know Nana. Nana believes that she needs to delete everything from her phone to the point where I am constantly fielding questions about how to retrieve deleted messages that contained important information. I've explained to Nana that I've never deleted emails from old email addresses. She'll never fill it up, ever. She called me one day. She was like, I need the phone number for Hotmail. I was like, the what? I need to call Hotmail about my email. I'm like, you can't. There's nobody at Hotmail, Nana. What's going on again? And I've begged her. I'm like, just stop deleting shit. Nobody's looking in your email. I showed her how to put them in a folder. She wouldn't do it. She thinks I'm like trying to. Anyways, so I wish I could see what she wrote, but I bet she even deletes the sent ones for some reason. I'm being serious. They've already done it, Billy Elliot. It was about the sugar tax. Anyways, guys, we have coming up our word games for this evening. So if you're new here, we play games in the evening time sometimes. We do a lot of things. We do a lot of funny things, okay? But word games. Tonight we have a new version plus an old version. Iron Brew, exactly. It's spelled IRNBRU. Legally, what happened was it used to be spelled Iron Brew, IRONBREW. But because of packaging rules and legislation in Scotland where it was created, they were not allowed to call it that because it didn't technically contain iron. And so they changed the spelling to IRNBRU, and it is an acquired taste, I'm told. I mean, I was raised on Iron Brew. It's bright orange, nonsensically, does not taste like, you can't describe the taste of Iron Brew. And Nana, like for example, we drink it on Christmas morning here in Canada as part of our Scottish breakfast that we have. We have a full Scottish breakfast. It's pop. It's pop. Scotland is one of the only countries in the world where Coca-Cola, I don't think, or at least it wasn't always the top selling pop, but Iron Brew was above Coca-Cola for a while. And it's weirdly delicious. Maybe some people that I've given it to in Canada have said that it reminds them of a bubble gum or cream soda. That never popped to my mind. It's always just been Iron Brew. But again, that's a Scottish thing. But anyway, so Nana literally found out that in Britain they changed the sugar laws. So if a drink has so much sugar in it, then they're charged an extra tax on that drink to sell it. And so the pop companies were given the opportunity to either change their sugar content or raise their prices in order to deal with the tax or whatever. And so Iron Brew evidently decided to lower their sugar content, which, I mean, I should be applauding, but there's a part of me that's like, guys, do you want to check out New Coke? There's a Wikipedia page on that. And I think you probably should just read up on, like, when people like your product, you should leave it the fuck alone. Make a new one that's cheaper, and cheap people will buy it. But you cannot get rid of your original, ever. Like, again, I don't know. I'm off to the races. You know what I'd love? If you guys can find in your countries, if they have Iron Brew there in the British section. New Coke was a marketing nightmare. But at its base, it wouldn't have been such a marketing nightmare if they had kept real Coke or regular Coke or classic Coke or whatever the fuck they ended up calling it. Because people want their choice. And listen, there's Dr. Pepper behind me. I've never tasted Dr. Pepper in my entire life. Ever. My daughter drinks it, but I've never tried one, even though they're right there. Okay. Oh yeah, so we're going to play Hangman. Sorry, got distracted. Also, if you guys want to send me more Larry pictures, I love getting Larry pictures. Yeah. Also, hi to everybody if you're new here. If you're not new here. Okay, well, I don't know, Richard Harrison, that's saying a lot because I was a Coke exclusive drinker for like, that math hurt, a lot of years. Let's just say since I was like 10, daily drinking Coke. And then as an adult, when I could drink whatever I wanted, I drank like many, many, many Cokes per day. Never Coke Zero, never Diet Coke. My daughter drinks Diet. Oh, look. It's not good. But I'm just only recently as an adult and as a growing adult learning to try new things and be okay with trying new things. Like for the longest time, I just got Coke because it's Coke and it's safe and I would like it. And there's just no question about it. It's like restaurant food. It's like, you know what you like to eat. And then branching out is hard because anyways, so, but I quit Coke over a year ago. I don't drink Coke anymore. I gained weight when I quit Coke. That was a hard pill to swallow, I'll be honest with you. I mean, I'm addicted to ginger ale. Like I've replaced it with ginger ale, which is a ridiculous replacement, but whatever. Baby step. Also, tonight's going to be an ADD night, you guys. Med check, line up, get your meds. If you're new here and this is a lot for you, buckle up.
To resolve this issue, okay, I'm going to call through the calendar and see who is here. Patrick Quinn.
Present, Your Honor. I'm trying to get my video going.
That's all right. You can sort that while I call through the rest.
There we go, Your Honor.
Robert Chester, present in court.
Okay, and the truth is that root beer makes me vomit. I don't like the flavor at all. Very accidentally, like a few times, I recall drinking a drink deeply, like thinking it was Coke, drinking it, like expecting it to be Coke, and like it was down my throat before I realized it was not Coke and it was root beer, and I'm like, oh, can't handle it.
Dale Luger, present in person. Arthur Foley.
Present, Your Honor.
And I would anticipate you are also Foley Plastic Surgery Center or the representative thereof?
Yes, sir.
Okay. Asia Bullock?
Present. Asia.
Asia? Okay. And Bigfoot Java. No response.
Did he just say Bigfoot Java? It's gotta be a company, but I'm.
This says it's about wages. So I do have something I will need to look up before I can take a look at any of this. I need to make sure that this can be here and not over in labor and industries. Carla Courier? Is it Carla? Charla. Thank you. John's Plumbing. No response. Evergreen Investments.
Yes.
As fun as that is, let me get the next video going, which, funny enough, is the same judge, but from yesterday. Oh, and this is why I remembered it, because I bet it's the one I start. Anyway, let's just watch it. Give me one second. Honestly, the part I really wanted to hear about this one was the beginning where he did that explanation, because we don't always hear that, to be honest. Yeah. Okay. Get rid of that. Gosh, that cop was pretty cute. Oh, okay, that's after. Focus. Focus. It's okay. We have I can stay on as long as I want. I'm the boss of me. Yeah. I'm all thrown off because it's like I'm what the fuck? You guys, this is never good. I've literally never seen this in my life. Auto renderer error. It was the video from yesterday. That's interesting. Okay, well, we'll play the original then. Just give me a second. That's weird though. I apologize, but we do it live if you're not aware. Oh, you know what we can start with? Why don't we start? I'll show off the first hangman for oh no, did I close it? Nope, I didn't. Mm-mm. Oh shoot. Hold on 1 second. This is so confusing. Okay, fine. Just get the video going, whatever. I know you guys love me and I know you don't care, but my ADD is starting to flare. It's going all nuts and it's, hey, fucking you up. That's the way we do it. That's the way it is. Oh my God. Seriously, my brain is not working. It's about time for another, well, it's about time for a weekend when I don't have live court to start. Which one was it, Mayor, on We Got a Case? I was trying to work today. 601.
Up before I move on to the, oh, nope, still one more on my 2 o'clock calendar. Before I move on to the 2:30s, do I have a Veronica Zavala?
Yes, I'm right here.
Did you hear my introductory remarks?
Yes, I did.
Okay, how do you want to proceed?
I want to contest it.
Okay, this is speeding. Raise your right hand, please. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, what would you, well, first, did you have an opportunity to review the officer's report?
No, I was not available to.
Okay. So I'm going to read it to you really quickly here. Okay. The trooper says with Washington State Patrol, training, what have you. The important part, though, starts in with using speed measuring device MPH-B3 dual antenna radar number R3063. At the beginning and end of my shift, I performed a full operational check on the above listed radar using the supplied tuning forks. He lists the numbers assigned to the SMD. All lights were working and an audio pitch was heard in conjunction with the visual display. SMD is speed measuring device. I sometimes don't say that out full. All lights were working and audio pitch was heard in conjunction with the visual display. I have received instruction in the proper use of this unit and am a qualified operator of the unit. I am a trained operator for this device, having been trained by Washington State Patrol certified instructor in the use of Doppler radar operations. This radar was operated as per my training and within the manufacturer's guidelines. The speed measuring device has been certified for accuracy by a factory-trained Washington State Patrol technician and found to be in proper working order. This vehicle is equipped with a vehicle speed sensor cable. The defendant's vehicle speed was checked using front antenna approaching opposite direction in moving mode. The defendant's vehicle was in lane 2 of 2 and visually appeared to be traveling in excess of the 45-mile-per-hour posted speed limit. Upon activation, the radar speed measuring device emitted a high-pitch audio and displayed a visual reading of the defendant's vehicle of 59 miles per hour. This display reading matched my visual estimate of the vehicle's speed. At the time I was operating this radar, the radar patrol speed reading and patrol vehicle speed were consistent with one another. The defendant was given an infraction for speed 50 in a 45, and then it lists the speed limit statute and declares under penalty of perjury, so on and so forth. Okay, so that will be the testimony that would be used against you. And apparently I'm feeling very generous with the county's money today.
Can anybody find a glaring error in what we just heard in the rundown there? It sounded pretty standardly traffic cop speeding ticket verbiage to me. I didn't even hear anything much missing. But let's just this guy is so funny. I love him. Again, we're again back in Thurston County, Washington. But let's just listen to what he says here.
Used against you. And apparently I'm feeling very generous with the county's money today because before you even testify, I'm going to say that this report lacks some pretty significant foundational elements for me to accept it as evidence that the radar was working properly. And so without that evidence, I don't have anything to say that you were even speeding. So, is there anything you want me to know that would contradict my dismissing this?
No, not at all.
Okay, I didn't think there would be, but you know. Okay, it's dismissed. Have a good day.
Okay, thank you very much.
That's cool, Jim Jr. I'm over the ocean in British Columbia, so it's West Coast, but this is weird. Like, I heard a thorough report. What foundation did he lack? Did he not say what county? Did he not say, he said the instrument, he tuned it, he talked about being post-certified, he was tool certified, it had been calibrated. Like, what did he miss?
That was it, Connor Bales?
No, it's in the Mr. Kamara.
Kamara.
Am I okay to leave?
Oh, yes, I'm sorry. Absolutely.
Oh, okay, thank you very much.
All right, thank you. Galaxy Note 20. Okay, Kamara. Okay, the person, before I move on to double check or triple check the 1:30 calendar, folks,
Okay, I'm already, my brain's fried apparently, but where was the first video that we watched tonight from? That was also Thurston County. Was it in front of a different judge or was it, no, yeah, it was a different, God, I'm gonna have to keep writing this shit down. Anyways, because this is really funny. It's just, you're gonna, again, when you watch a lot of court and a lot of courts, you get a very good idea of how different courts run, either efficiently, not efficiently, etc. Like sometimes you can even know when like certain people are on vacation because things don't operate properly when certain admin people are not there. And I'm not talking about the judges, okay? They may want to think that they are the most important part of the courthouse, but they aren't. They aren't. They know if they're worth their weight that the admins make all of it happen, the clerks, all that.
didn't show up, and move on to the 2:30 calendar. The person who is Galaxy Note 25G, I believe that would be a Mr. Kamara. Your hearing isn't until next week. So, I mean, you're welcome to stay on the line and see how these things go, but you're not on today's calendar, so I won't be calling you. Okay.
So somebody calling in a week early for their hearing, other people calling in at different times because different paperwork is sent out. Like it's a hard job. It's super duper hard. And it's not even all one person. I'm just saying like certain courts run super efficiently and certain courts don't. And I don't know, there's like this totally unscientific correlation that I find between like sort of nice-ish judges that are a little bit friendly and like disorganized courts, like Judge Maribel, you know? Um, okay, so now we're gonna start playing some word games, folks. And I will also get some court going after we get settled, I think. I'm trying to decide. Um, just give me one moment because what we have are, dang it, where are mine? Diddly-do, edit my games. Okay. Okay, 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 okay. I'm sorry. I know it's probably black screen. It's the worst ever. Larry, can you just hold it down for a minute, please? Okay, my friends. Larry, if I could have you assume the position up at the top of the screen. I believe you can take this spot for a couple minutes until we get going. So, this is just classic Hangman, guys, except I have indeed made the phrases, and I am indeed in charge of the guesses, so y'all can't fuck it up. But, um, basically, the hint is in the sort of title there. So when you come to court, you shouldn't ... And after that, um, now see, how are y'all gonna figure out amongst yourselves which guess to go with? Um, I think maybe buying vowels is a good idea, but you don't have to buy them. You know what I mean? Anyways, we have a few of these. I can make many, many more, but it's I got so distracted earlier. I had planned on making a bunch. We also have the other Wordle that we'll bring back in a bit, but I think A is a good choice to start with. So we could definitely start with A if you guys would like. Uh-oh. That was a no. You guys are, oh dear, there's no A. Oh, you might want to rethink your vowel. No, I'm just joking. No, who thinks anybody's in it? Nobody thinks anybody's idiots. Um, on a phone, you don't get the like drop down list of people that are in the chat room, but you do get like you can, if you type it properly, it will work and they will see it, is what I'm trying to say. Diddly potatoes. What am I trying to do? So we're gonna play this one. It'll be like a practice one. It's sort of fun. We'll play it together. I'm finding the court that I had. I know I downloaded it right here. It's where I got. Once you guys have decided on a letter for next, just let me know, and we can pick it. I don't even remember what the answer is now, to tell you the truth. So I can give you no help. Oh yeah, this is the court we're gonna watch. That's right. I actually like have no clue what happened with this, and it's baffling to me. Oh, I'm gonna have to add a new input. Oh, darn. Okay. I'm not able to look at the chat right now. Just give me a sec, guys. One moment as I do this. La 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 la. E E E E E E E E E E. I think E is a good choice. E, I'm gonna go with for y'all. Woo! Oh, that worked for you. You got a bunch. Okay, that's good news. I will let you ponder on that while I ponder on adding this new media source. Because I got this video because of a little snippet that I saw. I haven't had a chance to review it yet, so I want to watch it together and see what's happening. This is the second video. That's what we'll name it. And the window will be media player. Okay, no, you can't be that big, Judge. We're gonna have to condense both these. We'll have to figure this out, how to do them together, you guys. But I literally don't know what the answer is. Oh, I do remember now. Do I? Oh, yeah, I do. Okay. So this seriously popped up and I was like, what the hell is happening? Um, screen capture. Can you guys see that still? Is that too small for the hangman? I can also put it in maybe one of the screens in the video, but we'll see. Oh dear, I'm asking a lot though. My computer, things are dragging, you guys. I apologize. um, like my mouse is dragging. Okay. Okay, let's play the court and then I'll be in the chat and we will decide. You want to guess an R? You guys think R, R, R. Do you see what I see?
Okay, unmute everybody.
Good morning.
Good morning.
I think the other one is gonna get more line quicker.
Okay, we're already live on YouTube, just a moment.
Sorry, guys. Do you see what's happening here? You got it right, by the way. It was represent yourself. You got it absolutely right. That was 100% correct. Can somebody please explain to me if this is Abraham Lincoln? I'm going to make it bigger. I'm trying. Also, is Cindy Thomas familiar for some reason? Like just now looking at her, she looks very familiar to me. That has to be the oddest non-human person I've seen in a Zoom call ever. Have you, I mean, is that like a power move? Like, yeah, we got 3 people in this room. This one's wearing a top hat. Like, what? It's so odd. I'm fucking so confused. We have to watch the hearing. I have no clue what's going on in the hearing, but we have to watch it, obviously, because I need to know. Also, we'll play more word games in a minute. I gotta sort it out. It was slower than I like. Also, Larry, you can stand down for a minute.
Call us into session. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Thursday, June 1st, 2023 at 8:31 a.m. And this is case 2021-3295 DM Tracy Miller versus Mark Miller, attorney Lisa McNiff for.
Honestly, I could not have written the cases that I've shown you today. The craziness. This is real court. This is why it's so addictive. It's like, what? They had a what? Like, you wouldn't believe. There's a lawyer there. Why would the lawyer not know not to put the freaking mannequin in the court?
Plaintiff and attorney Cindy Thomas for defendant.
Okay. Well, we're back on this matter again. I guess I've read through all of the motions and the answers again, and at least Lisa's.
Oh my God, you're so right. He's also wearing a hat. He's so disrespectful.
Exhibits because we've got those ahead of time. Ms. Thomas, we didn't get yours until late yesterday, and I didn't get them until about 8:10 this morning, so I haven't had a chance to look at those, but I will obviously before we conclude.
And I have to admit, I added a couple more this morning that I was in trial all day yesterday with referee Snyder, and I realized a couple were missed by my assistant. But they're pretty easy.
Well, okay. Well, easy unless you don't get a chance to look at them.
So can I ask, Lisa, did you email those to me?
I did.
Okay, then we'll have to obviously.
It's your client's verified statement and 1 page of a transcript.
Okay, Ms. McNiff, do you wish to make any opening statement at this time?
I don't, Your Honor.
Okay. Ms. Thomas?
I'm going to reserve first.
Okay.
Mr. Lincoln? Mr. Lincoln?
Any, did you want to present any proofs, Ms. McNiff, or simply argue, or how did you want to?
I prefer just to argue, Your Honor. I think there's been so many proofs in this case. I don't know that the court needs to hear any more testimony.
Okay.
It was helpful, and I appreciate the fact that Ms. Thomas provided a copy of the updated property chart. And I would first state by saying that with regard to the real estate, we believe that those values comply with the court's order. With regard to the vehicles and the boats, we believe that that complies with the court's order. We agree with the value for the storage. We agree with Mr. Miller's, the first 3 of his bank accounts. What we have an issue with, as the court knows, is the Consumers Credit Union account. One of the exhibits I sent this morning, and I apologize, was Mr. Miller's verified financial disclosure that showed that on 12/27 he opened an account with Consumers Credit Union, and that account had in it $6,240.02. I also attached a copy of his testimony regarding that account that indicated that he thought he opened that account in January, not in December, in spite of the verified financial disclosure saying December, and that we've never had a copy of a bank statement that would indicate either the $6,240.02 or the $2,728.22. If defendants could provide us a copy of a bank statement that shows that amount on that date, we would accept it. We've just never, ever received a bank statement from that Consumers Credit Union account. All we have is Mr. Miller's verified financial disclosure that indicates 6,200 and some dollars. So I
Your
think
Honor,
that's an easy fix.
I just want to interrupt really quick. If Ms. McNiff is going to be talking about a verified financial statement that apparently neither you nor I have looked at, can we take a second so both of us can grab at least so that we have, I don't even have it in front of me because I don't have that ability in this room. Can I just go run and grab it real quick so we can at least look to see why she's talking about? It's going to be a lot easier, I think.
Sure.
Go ahead.
Okay, perfect. Thanks.
Are you telling me that you don't have the ability to travel in time? Because, I mean, oh my God. Also, look how many birds are in there. Those, like, nice birds. I hope aren't. Well, of course they're dead, but. God. Oh, Jesus Christ. This is Michigan. So, what is in the middle of that bookcase? Is it like a top of a statue pillar? I've definitely done a case with these lawyers before. I remember Miss McNiff's office, and I wasn't impressed the first
Your
time.
Honor, if you're looking for that verified
I am.
financial disclosure, can you find that account, or I can tell you where it is?
No, I have it. It's number, it's your exhibit 6.
Correct, yeah. And I believe it's on no. It's the last page of the bank account listings.
Oh yeah, there's a microphone and a water
Bank accounts.
cup on the Cindy Thomas table. The microphone has a top mute button. Like as in she taps the top and it mutes it.
Gotta find it. Definitely a lot of. Is that before the personal property or after the personal property?
It is,
Oh, I think I see it there.
I think it's before the personal.
I got it.
Okay.
Do you think Abe has a dedicated chair in that office? Did they set this up? Did somebody roll Abe in and position him for the camera? At one point, somebody had to. Somebody had to. Who? I bet he's worried, like, why does my lawyer have a giant? Oh my God, imagine if it was a male sex doll. Like a female, like oh my God. Ew, 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 ew. She like dresses him up to keep him at the office, and no, she's like, nobody knows.
Okay, thank you. I'm back.
Okay, good.
So that's my entire argument with regard to that Consumers Credit Union account. I'm just asking for a statement that supports the $2,728.22 figure, or I'm asking the court to use the only other documented number that has been provided at this point.
Okay, just clarify for me, Ms. McNiff, if you could. I'm looking at your motion for relief. That was filed on 3/31, and my recollection in that motion, you don't mention anything about this account. Am I correct in that?
That is, I believe, accurate. I thought that was an issue that I had brought up previously.
I'm not aware of that.
Okay, so the court will not be entertaining that.
No, my thought was today that we were addressing the issue concerning the retirements. And that was my understanding.
Oh, and only the retirements, only the
That's-
co-option fraction?
That's what I thought we were addressing today.
Okay.
Your Honor, I thought we were addressing both the retirements and the FSA account.
Yeah, well, yes, correct.
Because it's not a retirement. Okay.
Right.
And just for for clarification, just because I want it to be upfront and whatever. Ms. McNiff indicates that as of the, with regard to the consumer's account, it shows on his fifth form that it's as of 1/10 of 22, which is not the date that the division was anyway. And our position is he deposited it in between, like the very first part of January. So I believe that that does conform, just because I just want to be open.
We've just never received a bank statement that indicates that, and so it's a significant difference. If we could receive a bank statement, that would be so helpful.
Well, maybe you can do that, Ms. Thomas, because the court, again, it's not the subject of the motion. It wasn't the subject of this hearing. And as a result, I'm not going to address.
Shit. If Abe got up and said, I will take it on horseback. Seriously, what in the hell is happening here? How is this not even being addressed? This is this is insane to me.
It, so you can provide documentation to Ms. McNiff, and then hopefully that will resolve that issue. If it doesn't, you can bring it back in.
Well, then I'll just move on very quickly to I think what is the easiest one, which is the FSA account. I've provided to the court the transcript where my client testified that she believed she had about $200 left in that account at the end.
What if Abe was one of their prized possessions that they're fighting over, and this is like a proof of life? Oh.
Of 2021, I've provided documentation that from KCCU that Ms. Thomas has had, and I believe Ms. Thomas in her Exhibit B actually shows that the amount at the end of 2021 was $227.36. The Blue Cross statement also shows that the balance at the end of 2021 was $227.36. And I'm sure the court understands the way this FSA works is money is deposited for the purpose of using it for uninsured medical expenses. It's a small amount because it doesn't roll over like an HSA does. It's a use it or lose it type of account that people use. And with 4 family members, it would make sense that would be used up by the end of the year. I don't know what else to present to the court other than my client's testimony and the documents that show at the end of 2021, on that date, there was $227.36 left. The court can see from the documents, it shows like 1,900 and some that is deposited at the beginning of the year. And then it shows the deductions, which are over 1,700, which then leaves a balance of the $227.36. So we would ask the court to use that number for the FSA amount.
Okay.
Then do you want me to continue, or do you want Ms. Thomas to?
Let me ask Ms. Thomas, do you prefer to address that now or all?
Or would you have Abe do it? We're all wondering why he's here, why he hasn't taken his hat off, if he's wearing pants, how many holes you guys decided to go with for this model. You know, you got the basics, but there are extra holes you can get.
At once when you argue.
I think that because the FSA is a separate entity, I think it's better probably to address it now. And then when we get into the other, we can talk about more stuff. Our concern is on our Exhibit B, which it's notable. And the reason that we did the subpoena and included that as part of our exhibit, does Judge, you have those, right?
Yes.
Okay. The reason we included the copy of the subpoena is we had sent the first subpoena, did not receive anything about the HSA/FSA account at all.
I think it's
Thomas, I'm not concerned about what you first received. I'm concerned whether it's accurate or not.
Well, okay. But the idea though, I guess my point is that, so we did a second subpoena that stuff was due in April. We got it April 28th. It was due April 6th. And when we got that, we received what I attached, and that was the email from Ms. Miller to Ms. McNiff. And on the I think it's the next to last page of that statement, it shows the year-to-date balance is 227.36, but the coverage start is 1/1/21. So the interpretation is that that's how much was there on 1/1 of 21. In addition, if the court looks at the actual objection that Ms. McNiff had with regard to her motion for relief about that, the exhibit A that she provided was in fact a little bit more expansive than this exhibit, one that she had given us prior to trial, but certainly not expansive enough. We've already specifically looked at these particular exhibits with the court prior to this. What was kind of shocking to me, quite frankly, is that we now receive an exhibit that we just received, we've never seen in trial before, that all of a sudden now we see on page 2 of.
Ma'am, you are sitting beside a life-size realistic Abraham Lincoln. What could be shocking to you in your life? What if Abe is the client? I mean, I have so many unanswered questions. Is this a sales point? Like, you always get 2 bodies in the courtroom with our team, or what? I'm amazed.
Their exhibit 1, we've never seen anything with this $1,732.54 ever before. That wasn't what was attached to her initial objection or concern about the FSA account. That was never a number. And what's interesting is it shows on on the next page, it shows coverage end as of 12/29. It shows coverage end and it's zeros. These were never provided to us before. We never received a Blue Cross statement before. We never received any of these documents before. And now all of a sudden, when we're going to specifically talk about this, we have new documents that we've never seen, have never been provided from a place where the opposing party is the CEO of the company. We just find it very concerning, particularly when the documents we've used from the beginning up until now were the ones that Ms. McNiff had provided previously and were attached to her actual objection to the entry of another order, including and was discussed also including with regard to her objection with regards to our qualified domestic relations order, because the number was wrong. Again, all because of this. And how do you manufacture this document now when we've never had access to it before? And now all of a sudden it's like, oh, well, here's our proof. It's like that.
Ms. Thomas, how long have you had your exhibit B? Because I'm looking at that now. You've had that, have you not?
We have. Yep, we have.
If you look at I'd say the very end page or one before it says coverage ends, there's a page that shows the plan balance at 227.36.
With a date of 1/1/21, and that's not the date we're looking at.
Your Honor, my assumption, it's just an assumption, is they fund this plan at the beginning of the year.
Well,
but my guess is because it's 1/1, it's a banking holiday. It probably doesn't get funded until the next business day. So
the document that we've used up until this point is if we look at Ms. McNiff's motion for relief from the judgment.
Okay.
That's the document in its exhibit A. And we argued this the last time we were here. I believe it's on page 7, and that's just because I remember that was the page that we were on. It shows, And again, this is the same, it's part of the same documentation, obviously, from the way it's set up. So actually, if we look at, hang on, oops. I think it's page 4 of that document. It shows, nope, it's page 5 of that document. It shows the coverage start of 1/1 of 21, which is the beginning of the year of the date that the court ordered it to be 12/29 of 21. But if on page 7, it shows plan balance of 1999.90, year-to-date balance 1999.90. That's the number that we used.
Where is that again?
It's on page 7 of her exhibit A, attached to the motion for relief. That's where I got the number. I didn't pull the number out of air. That's where I got the number.
Well, they've been using the higher number since well before my motion for relief.
Right, but we've always, because we had this document that was provided, and we've always used that number. It's never changed. We've always used that number. And I guess the thing of it is to now all of a sudden have additional documents is concerning, but even more so, a couple of our exhibits were added just simply to the fact that, you know, this court ordered child support as of the end of December, and then upon motion of counsel at the finding, moved it to January 10th when the party moved, when Mr. Miller moved from the home. So the defendant didn't have to, or excuse me, plaintiff didn't have to start paying child support at the same date. Now all of a sudden we have that date on this one, but now we want December 29th. He was still living there. If they're all living as a family, how can it apply to one and not the other? Why would we not take the 1/10/22 date? It makes no sense. It's like whatever's to the advantage of Ms. Miller is what they're asking for. And I certainly understand it because Ms. McNiff is required to represent her client's interests. I get that. But what we were provided up until now, the entire time, was this attachment A from, or exhibit A from Ms. McNiff's objection. And that's what I went from. I went from their information, their exhibit.
Okay. Anything else, Ms. McNiff?
No, Your Honor.
Well, what I'm going to do is obviously there's additional exhibits attached. Those exhibits, again, were not available at trial. There's other, again, exhibits that were submitted. Those were what the court utilized at that particular time, as well as the testimony. And obviously, I would say that over the period of this trial, there was a lot of conflicting testimony in this matter, and the court is troubled by the fact that, again, we have attempted to get this correct as opposed to get an expedited resolution. But it does appear that the exhibits previously exchanged in this matter did again show a balance of, well, there were two numbers. There was the 1979.90, and then I think there was a 1999.90 on other exhibits. And that is what the court utilized at the time of trial. The court is going to remain with that number, as that's what appears to be the number that the parties had submitted at the time of trial. And that's the only thing that the court can utilize as it relates to making a determination and finding this matter. So the court will affirm that use of that number, notwithstanding subsequent documents and subsequent, I guess, explanation. So, Ms. McNiff, you can go on to the covenanture.
Thank you, Your Honor. In our exhibit 3, which is page 171 of the transcript from one of the days of trial, both Ms. Thomas and Mr. Miller at that point acknowledged that Ms. Miller had 401k funds that started out at Omni. And what we have asked is that the coverture fraction be applied using her start date at Omni Credit Union, because she accumulated 401k funds in her credit union National Association 401k there, which was compatible with her 401k at Kellogg Community Credit Union and rolled over. It appears Attorney Thomas has at first only used the coverture fraction with the start date of service for Kellogg Community Credit Union, and then was inclined to, I believe, carve out the premarital portion, or carve out the premarital portion, including both the Omni and the KCCU premarital portions, which it simply isn't accurate. We don't have the number for how much my client accumulated during her tenure at Omni, because she worked at Omni from 1986 until 1993, and there simply aren't records back to 1993. However, there has been an acknowledgement by the other side that she did in fact work there, that she does have premarital funds from Omni that were included in her KCCU 401k. The court did order a coverture fraction, and generally the purpose of a coverture fraction is to take into account all premarital funds in a particular account. And it also allows the accounting for any increase in the principal, any passive increase in that principal that was accumulated prior to the marriage. So we're simply asking the court to take note of the fact that there was an acknowledgement that my client had 401k funds, that they were rolled over to KCCU, and to apply the coverture fraction using her start date at Omni Credit Union.
There's no dispute on that, Ms. McNiff. Obviously, I went through the transcripts you referenced as exhibits. I remember the ruling in this matter. I just trying to, I guess you do the application of that. And I see on paragraph of your motion, paragraph 28, you said defendant's coverture fraction omits 80 months that plaintiff had with Omni. And then you reference exhibit C. So I guess some of our issues, and I've had this in other cases where you can't get documents, so we can't say, okay, it was X amount of dollars, which obviously creates some difficulty. So you're saying, what you're saying, because quite frankly, is we should do that and utilize the additional 80 months that she was with Omni. And then that would bring us to, again, the number that she had with KFCU.
That's correct, Your Honor. And her start date with Omni was June 1986. And I believe that Ms. Thomas had that date.
Okay. Okay. The only issue I take with that, maybe you can correct me, Ms. McNiff, is that we obviously don't know contribution rates. We don't know contribution amounts. And just because we use the months, that may skew the actual balances if we don't know what the rates were.
I understand that, Your Honor, but going back to the 1980s is virtually impossible.
I understand. I'm just, that's my query here, that I'm saying, you know, darned if you do, darned if you don't. If you do, then there's a potential for other error as well. But okay, thanks. Anything else?
No, Your Honor.
Ms. Thomas, you obviously acknowledge and you recognize that Ms. Miller did work that 80 months with Omni. And again, if you omit those particular months in the coverture fraction, then aren't we effectively not giving her credit for that?
Absolutely not, Your Honor, because we know we have also the dates that she we know how much she had in that account at the time of the marriage. And our understanding was that together was initially, and what we believed all along, quite frankly, having no idea about the coverture fraction. And I have distinct argument that I'd like to make about that. But anyway, our understanding was
how much did she have in that account? Then you're saying you knew how much she had?
The 46,000 that was in KCCU, our understanding was she had rolled some from Omni, the rest was from KCCU, but she could not break it down into an individual. This is how much was Omni, this is how much was KCCU. So that's no different than Mr. Miller's Baird account that it was his personally initially, and then he didn't close it and change it. He added Ms. Miller, but we didn't know how much. We couldn't show because their Baird's records don't go back that far. So it became all marital. So we understood that because yes, those accounts were combined, but as of the date of marriage, we did have a number. So our understanding and on the property chart where it shows, frankly, that the court used throughout the trial, it shows that we understood that there were X amount of dollars that were taken out, and I believe it's our exhibit D or E. Our exhibit E shows the same exact statement that we've looked at before that was provided by the plaintiff, is that on the date of marriage, and this is the April 22nd period, April 22nd, 2001 period end date, she in fact had in her Omni account $16,686.96. That was then rolled over into Baird, and her separate Baird account. We're not disputing that. On the next page, the next exhibit, it shows in there how much is in her KCCU 401k plan. And we see that in that 401k plan on that date is $46,836.34. So if in fact this represents the Omni as has been contended, then she didn't have a KCC plan because this is her total plan amount. So if this is all Omni, then this isn't KCC, and the entire KCCU one is all marital. If this is Omni and KCCU and they can't define it separately, then this is how much, and it's assumed to have been earned during KCCU because she kept her Omni one separate. So, but we can't do it both ways. What
Okay,
they're asking.
hold on. Let me ask Ms. McNiff. Ms. McNiff, do you acknowledge that, again, at that date, which would have been right around the date of marriage, that she had in the account the $46,836.34?
We do, but we don't believe that a carve out of that exact amount makes any sense or is reasonable, for the reason that those funds were invested and they were receiving interest and dividends, and even over that period of time, at basic inflation adjusted, that money would be worth at least $125,000. And it could be worth as much as $200,000.
But that was the balance at that time, correct?
Correct. We agree with.
Hold on, greedy lawyers. I just thought of something crazy. Listen. Who is it? Is it Mama? What was it? Mama? What was her name? Mama. Why can't I see it? You know who I'm talking about. She said she's been watching this case for a while. There it is. Mama to two beauties am I. Okay, has Lincoln been there the whole time, my friend? Like, I'm stopping the stream. We need to know now. CEO of a credit union. Oh, the fucking juice. And these idiots. Listen, though, that's the thing I learned about when I worked at a bank. I worked at a bank. I'm from Canada. It's very different here. However, like, you can't own a credit union or you can't own a bank here in Canada. But you're telling me Abe Lincoln has been in all of the hearings? He lives in Miss Thomas's office. Somebody find me the sex doll version, please. I want to compare them. Okay, let's vote in the chat. Would that be a deal breaker for you if you were trying to pick a lawyer and you walked into her office and she had a life-size Abraham Lincoln seated at the table with you? 1 for yes, 2 for no, 3 for what? WTF? Once again, the current poll is, would that be a deal breaker for you if you walked into your lawyer's office and saw that they had a life-size Abraham Lincoln sitting at the table? 1 for yes, 2 for no, 3 for what the? It's crazy to me. I'm not turning this off until he's gone, and you're telling me he lives there, which just, do you think he has a recording device in him? Do you think, what is the purpose? How can it be? I mean, I'm I'm perplexed at the just audacity. It's like you brought a friend to court, but you didn't tell them that they have to take their hat off. It's like you're a lawyer, you know the rules. Even your freaking fake historical guests should have to take their hat in court off. It's such a weird flex. I mean, people flex with the weirdest things, but that is a very weird flex. If it turns out to be an animatronic one, like from Disneyland or something like that, and she's paid like uber too much money for it, I wouldn't be surprised. Except for, I think the TV in the background is genuinely from 1999. Maybe it's a carpool thing, Toby? You think so? No, because Mama, is it in the same exact position every time or does it ever move slightly? I know you know. I know you know. Never moves. Never moves. So the camera angle has been static in that spot for a long time and Abe has been a fixture, is what you're telling me in this office. Because I'm going to tell you something right now. I mean, I literally grabbed this video. I follow this judge, but I follow 600 plus courts. But my eye sees things and I noticed it in a millisecond of the looking at the screenshot. And I was just like, what the fuck is going on there? I gotta get that immediately. I know he's been there for 32 minutes, but do you know what I mean? You know what I mean? Like she's watched the hearings from before. I'm so like, it's crazy. We don't have any carpool lanes in Canada. Well, in my little island either, but well, probably some, but we have a bus lane that everyone's mad about, except for the bus drivers. Awesome. I will check it right now.
Okay.
Also, I think it's
So
awful
that
that
was
I
the
have
balance of the
personally. Hold
Omni
on, Judge.
at that particular time.
Can you fucking not interrupt me, please, Judge? Come on. You obviously let some shit slide because I know judges that like. Do you think Judge Bryant would what would she? I'm just amazed. Do you think she wants people to ask? That's why it's on the screen. Anyways, God, was I gonna fucking say there? Judge interrupted me and I can't fucking remember. Thank you so much, dude. Um, HOV is high occupancy vehicle. They have them in Vancouver, but not in Victoria, the part of the island that I live on. Oh, that's what we're gonna do after this. This judge. Oh, I remember what I was gonna say. I personally, I believe I have covered this case in part before in one of my videos, and screenshots. I can hear it.
correct. And I think if there's going to be a carve out, there should also be an adjustment for increases and decreases for that period of time.
Okay. Well, at least we have that, which I guess puts us ahead of where we were previously, because we have a number showing what was in that account at that particular time. Okay, Ms. Thomas, go ahead. I just wanted to see if we had confirmation of that.
No, that's fine, Your Honor. And based upon that, my true argument in this case is that, and again, I'm just gonna do kind of my argument overall as to this.
Actually, we have something more intriguing going on in the chat, even than Abe Lincoln here. Wendy has just informed us. I'm assuming you mean daughter-in-law, but I'm really going with Dill has a life-size cutout of Vladimir Putin in her dining room. I have a lot of questions. A lot of them center around a Dr. Phil episode that jumps to mind. If anybody else knows the Dr. Phil episode I'm talking about, please talk about it in the chat right now. Seriously. Oh, gosh. I get having decor and like fun decor. I love it, but like, is it in good fun or is it worrisome? Those are the questions, right? Like that's the balancing act we all have to figure out when we think about the things people do around us, I guess. Yeah, let's keep going. We'll finish this little part and then I'll give you guys a choice on what we do next. We're doing a little different this evening.
Whole issue about the accounts. Marriage is a status that legally terminates only upon death of a spouse or the entry of a judgment, according to Kurtz v. Kurtz. And that's 178 Mich. Act 284, 291. There is no de facto divorce, and Michigan jurisprudence does not recognize consensual divorce. Michigan law provides that it's from the time of marriage to the time of divorce, and including the requirement to make a divorce effectual, which means that this divorce didn't happen until, well, actually, because of numerous issues with the judgment of divorce, this divorce didn't happen until March 27th of 2023. And that was all during the marriage. By excluding from consideration plaintiff's split dollar KCCU compensation package to Pacific Life and Penn Mutual, which vested after the filing of the divorce, but significantly prior to the trial, caused by, through no small part, frankly, delays at the hands of the plaintiff, this court has already divested itself by ordering post-marital increases in a premarital asset, which has been commingled with marital property, and that there's no ability to identify. Because and that's fine, that's what the court ordered, that's fine. But this alleged further transfer of premarital contributions from Omni into another premarital asset, and then allowing the asset to be credited with another premarital asset, and then adding those months together and doing a coverture fraction, is frankly double dipping, because you're giving the benefit of carving out that amount and the number of months that it was earned. And we don't even know for sure how many months of that KCC one was earned. The court's already ruled on part of this. The court's already ruled that the money that was just Omni is Omni. The court already ruled that we're not putting Omni into the KCCU one. The court's already ruled on those two issues. So, which is a little concerning to me that we're even here, because that's already been argued. What my bigger concern is that we know at this point, we knew at trial, we knew now, we've always known that in the plaintiff's account, she had money at KCCU that, in fact, $46,000 of it was premarital. In addition to that, we knew that the Omni money that showed on the exhibit we just looked at was rolled over into the separate Baird account that's just in Ms. Miller's name. Everyone's agreed on that since the beginning. There's no property charts. There's no anything for Ms. McNiff that shows anything other than that. But as to the coverture fraction, frankly, while it's necessarily used in cases where there's no clear way to make a determination as to premarital versus marital, such as pensions, railroad retirements, things like that. I mean, there's no way to know. But in a situation, where it's not a defined benefit plan, it's actually a defined contribution plan, we do know. We know now, we knew then, we've always known. And to choose a valuation date, obviously 15 months before when the divorce finalized, and then divide that down with a defined contribution down by a coverture fraction, it makes no sense. We have the numbers. Although Ms. McNiff appears to be arguing that any attrition or increase in that should be separated out. That's not what the cases represent at all. We're 4 months past now the finding in this matter. We're still at odds with the court ruling. It's an easy fix. And the easy fix is what was there before the marriage is premarital and everything else is marital. That's the way that it should be. And that's the way, anything that's earned during the marriage, and that's from the time of marriage until the time of divorce, which we were all the way up until March 27th, still married. That is all considered marital. The case law is frankly quite clear, as stated in McNamara v. Horner, who was relying a little bit on the Reeves case, and they say that that's inappropriate because the increase in value of the accounts is not wholly passive when in fact the parties are continuing to contribute to those accounts. Because they're continuing to contribute to those retirement accounts, it's not passive. Therefore, that's not to be, McNamara is very on point in this. The court's chosen method of substantially altering from that significant way that is evaluated. From the property chart again that the court used, it showed on there these two accounts marked out as they were premarital and that we weren't including them as a marital asset. To now do them by coverture fraction and take into account months we can't tell what's what. When we do have numbers, we have accurate numbers, we have absolute numbers, we've always had these absolute numbers, makes no sense. I think that we've already strayed a bit because again, the Penn Mutual one did vest during the time of the divorce. The parties are still married. They were both investing. They were investing in their 401k. Mr. Miller has his premarital SEP. They were continuing to invest in these accounts. And so, frankly, it's commingled with marital. We're fine with taking out the part that's premarital, but any increase in those happened during the marriage. And if it happened during the marriage, it's marital. Case law is very clear on this. And we're asking the court to consider that and consider case law because, frankly, this is, it's a huge difference in this case. We're talking $250,000 in this case. It's huge. And to think that, well,
yes, we understand. Otherwise, you wouldn't be fighting about it. Guys, if you love the freaking backgrounds that I sometimes somehow come up with on the fly, not me, it's Richard Harrison in the chat. I've put the link to some of his stuff there. And I want to make Abe an absolute permanent fixture somehow. So also we have coming up something a little bit different and a little bit new that we'll be showing. It is petty small town life that I am going to be sharing with you guys in a fun format. I think you'll really enjoy it. And then probably some more court. And I think we'll do Wordle while I do the petty stuff. But anyways, let's continue. We'll just let this finish, I guess. Yeah, I need a couple minutes, so we'll let it finish and then we'll keep going. Also, I am reading the chat. I am also just sorting out things, switching from day to night. Y'all know how it goes.
we should take a coverage or fraction of a contributed, a contribution plan versus just a defined benefit plan that we can't determine is not realistic, when in fact the increases in value of that account, whatever Ms. Miller had in there, happened during the marriage. As to her Omni account that was rolled over into her separate Baird account, we understand it was always separate. It was always apart. It should be hers. We've always considered it just hers. However, when we're considering an account, an amount of money that she had, she continues to invest into that every month, actually every pay period, I believe, a significant amount of money. And that's hasn't come home to the marital estate. It's been put in there, and it's a significant amount. And to believe that should be what it's coming of its attitude during the marriage, to believe that you can take what Ms. Miller makes today, what her earnings are today, and the amount of her percentage that she's able to put into that today, and compare that to what she made, what little she might have made at Omni in comparison, or even early days at KCCU in comparison. We know that she worked at KCCU. We have a start date of when she worked. And as of, even with the Omni rolled into it, she only had $46,000 in 2001. And to now, all of a sudden, we're giving all of the benefit of all of these years to that account and counting as that all months are equal, when clearly she didn't make $360,000 or $80,000 back then. And her percentages are certainly drastically different. So I just believe that doing this as a coverage fraction at all is inappropriate and not in line with what a reasonable person would assume, for one thing. But beyond that, it doesn't conform with McNamara at all. And because we're still arguing about it and we still don't have an agreement on it, I think there is a solution. And the solution is for both parties, how much did they have at the time of when the marriage was? That's theirs premarital. Anything over and above that to what it was at the valuation date of the court is marital. Whatever valuation date the court used, in this case, 12/7 of 21, from whatever was earned from April 2001 until December 7th of 2021, that is marital, no matter what. And then the basis of it, you're getting what you had when you came into the marriage. And then anything else you did and you added to it, you increased that with marital money. It's a commingled asset anyway, but we understand premarital, and it's accepted that way. It's done that way all the time. However, to use a coverage fraction when we have the numbers, and then to ask to double dip and have that carved out, and even though we don't know how much of that time that is Kellogg time and how much of it is Omni time, we're asking for a double dip and maybe even a triple dip on this one, because we've already set aside the Baird account as Ms. Miller's separate account. So she's already gotten that part of her Omni money. If in fact Omni money is put in here too, she's already gotten that part. So to also give her credit for the months of a portion of the Omni account in a coverage fraction is highly unequitable for Mr. Miller. And that would be wrong. So we're simply asking that the court, we have the numbers. She's already got her Baird account, which is part of her Omni. We have the number of how much Omni was at the time of marriage. We have the number of how much Kellogg was at the time of marriage. Frankly, we have the number as to how much that Mr. Miller had in what is now the Wells Fargo was, I believe at that time, Prudential account. We have all those numbers. Take the number as it was as of the date of valuation, subtract the number that they had before. They continue to contribute in both of those accounts during the marriage, and be done. And we can be over the whole argument.
Okay, thank you.
Your Honor, can I briefly respond?
Go ahead.
Your Honor, the court has been adhering very strictly to its original finding. And it sounds to me like Attorney Thomas is requesting this court overturn its decision regarding the coverture fraction. The court ordered that the coverture fractions be applied to both parties' retirement accounts, which is fair and reasonable. But to cherry pick and say only one account won't be subjected to a coverture fraction is completely unreasonable. Yeah, I agree that it's quite a bit of money. However, if you look at $46,000 indexed in 1986 to the S&P 500, you get about $200,000 that would have grown over that period of time. That's the whole point of a coverture fraction. The court understands that. That's why the court ordered that all of the retirement accounts be subjected to the use of a coverture fraction. So we would ask that the court simply do what it's been doing with all of its other decisions and maintain the finding that the court issued originally.
Okay, thank you. Well, in this matter, obviously, as the other issue, there's extreme confusion in this particular matter based upon, again, a number of things, where the funds were from Omni apparently rolled into the Bear. That was kept separate, so there's no dispute on that. And those were to be excluded. Obviously, the defendant's account, we were not able to exclude because he was not able to identify any amounts, and that was all commingled. We do have a lot of issues of commingling in this particular case. It's been alleged by Ms. McNiff that we need to look at, again, the growth of these particular funds, but again, that's speculative as to, again, what was the growth amount. We don't know what that is. The issue is both parties, I think, would acknowledge that they made different money at the start of their marriage than they're making, let's say, in the last few years. So if we count each month equally, that does in fact present an inequitable result as well in this particular matter. There's no doubt the court used a valuation date of 12/7/2021, and then we have the marriage date, and that was the purpose of the court using a coventure factor would utilize those dates from the date of the marriage to the valuation date for purposes of determining the marital portion of those.
What if she's married to the Abe Lincoln doll? What if it's the only man in her life that never lets her down, never turns his back on her? It's always there. Just, he's there.
Those accounts. I haven't heard anything today that's going to change the court's ruling in that particular matter. I will continue to use the date of marriage through the 12/7/21 date. And I'm not going to speculate as to what the growth was from different amount of monies that were essentially commingled and put into a marital asset, because you would never end. I mean, that would be you would be speculating forever as to what it was, because there's no way to do that. And as a result, that's how the court is going to rule in this matter, that will remain using that particular covenanture factor, and that's going to be the ruling of the court. So that will end the matter.
Your Honor, can we ask questions?
Yeah.
Okay, because that's what you ruled before.
That's,
And it was
well,
still
I was hoping that you'd take it as that's how I ruled before.
Right. And that is what you ruled before, and that's fine. But whether we agree or not is immaterial. That's what you ruled before. There still came the question. And so, because I just want this to be done and have a final order and move on, stopping the bleed for everybody, quite frankly, including the kids. So because we don't know how much of that premarital was Omni and how much was not, when we had divided it, we had used KCCU as KCCU for the date given them the whole time, even though like that she worked at KCCU, because we've already given them Baird for the Omni months. So if we use the number of months that she worked at Omni added to this, she's getting money for Baird as well as Omni. So the question I have is to just make sure, my understanding is that as to the Omni that went to Baird, that's hers sole and separate.
There's no dispute on that.
As to the money that was combined with KCCU, we can't delineate it differently. So we're going to use it from start of time when KCCU started until the marital date between. And it starts with her start date at KCCU. That's the real question. Does it
Right.
start at her start date at KCCU? Because that's where the account is.
Well, no, we wouldn't use her start date because that's not the marital. Use the marital date as the start date.
Right, but but the marital portion is the numerator in a coverture fraction. The denominator would be her
Right.
start date in order to give her credit for that start date.
Right, because she would be getting credit then for the pre-marital portion.
Right.
That
So
was
the
intent.
denominator is
That was
the
the
start
intent.
date at KCCU, correct?
I don't understand at all.
Okay. Well, what she's saying is correct, is if we're using as the numerator would be the date effectively would be the date of marriage. The denominator is the date that she started at
Well, so it's
FCU.
the months of the marriage and the months of service. It's not the date, it's the
Right,
months,
right,
right?
yes, but
Okay.
you utilize the date.
Okay,
Just to give you the month.
so we've got the months of marriage, and then for the months of service, what are we using?
Her total months of service, the time at KFCU.
Only at Kellogg Community Credit, Union,
Correct.
even though that includes Omni funds.
Well, the Omni obviously went into the Baird account, which was a separate account. And we don't know what the amount of the Omni funds were.
We don't.
Here's the thing. I failed math. I've told you guys this a lot. I failed math. I failed math many times. I apologize. I'm sorry. It's not my fault. My brain is different. I have aphantasia. I think that has a lot to do with math. But more importantly, I worked at a bank for oh God, that's too bright. Okay. I worked at a bank for many years, and I learned there are really smart people that know all this stuff. And we've heard lawyers constantly say, "Oh, I'm not good at math. That's why I became a lawyer. Oh, I'm no good at math. I'm a lawyer." So are there good math lawyers? Are those tax accountants or tax lawyers? I'm being absolutely honest right now. The joke I've heard very frequently from lawyers and judges is about how they're not good at math. And it seems so weird to me that they can't just figure this out. I know they're fighting over lots of money and which values and all this kind of stuff to use, but well, honestly, to be honest with you, real estate and a bank lady, they're going to have the most convoluted finances in the world. This is, yeah. Anyways, they're literally talking about things that happened before I was born. Her job started before I was born. I know tax law is very specialized, but I don't think these are tax lawyers. I think these are divorce lawyers that are hanging out in the tax arena or something. When you say there's a formula, it usually it means to me that there's probably a way to get that done properly. I just don't understand why that would be. Charles, thank you so much, my friend. I hope you have a good healing sleep tonight and have sweet dreams, okay? We miss you and we're thinking of you whenever you're not here. And we're happy that you're on the mend. And also, congratulations on your weight loss, Charles. Very significant. You did it almost overnight, really. I hope that was not too much of a joke. Yes. Anyways, let's continue. I love you, Charles. Know that.
Don't know the amount of the Omni funds, but we do have a clear acknowledgement in the transcript that Omni funds from Mr. Miller, that Omni funds were
But we don't know, and I'm not going to speculate as to what's in there. We're utilizing as the numerator, again, the time when the date of the marriage, however those months are, and the denominator being the total months at KFCU. And that gives us the covenanture fraction because that divides that particular account.
So she loses essentially all of the funds that she rolled over from Omni.
No, because the funds she rolled over from Omni went into the Baird account, and that's a separate account.
Some of them did, but there were two Omni accounts. One acknowledged completely went into the Baird account. And like I said in the transcript, Mr. Miller acknowledged that there were funds from Omni that were.
But again, I guess what I'm going back
went
to,
into the KCCU 401k.
and it's no different than Mr. Miller's account when we had no idea what went into from the Wells Fargo into the account that he rolled over and commingled. There's no way of knowing what those funds are, just as there is in this. There's no way of knowing what those funds are. I'm not going to speculate as to what the funds are. I'm not going to put a dollar amount on what the funds are because we don't know. And so when the parties don't have that information and don't present that information to the court, I can't speculate as to what that is. And unfortunately, that may result in some, I guess you say, disadvantage to a particular party, but I'm trying to do the best we can with the information that we have. And that's how I'm going to resolve it with that fraction. So Ms. Thomas, you can prepare that order, which will confirm what we've done today.
Okay, Your Honor, can we look at my exhibit I at the bottom? Because I think that's what we've already done. So I just want to make sure that just so that there's no question and no objections to an order that I prepare. I'm more than happy to do the order. I just want to look at it because I believe that that's what we've done. But if that's what we've done, then it also eliminates the objection to our quadro that's been presented to the court as well. And that could be entered as well. I want to make sure.
Okay.
I agree that this complies with what the court just said. I won't say I agree with it, but I agree that it complies.
Okay. Ms. Thomas, does that give you your answer then?
Well, it does. If in fact, then based upon that, if Ms. McNiff is also then taking away her objection to our entry of our qualified domestic relations order, and then that could actually be entered today.
Well, I think she's obviously, she acknowledges that Exhibit I does in fact provide and reflect the court's ruling. She basically doesn't agree with that ruling.
No, I know.
That. So that'll be subject to clarification or something from the Court of Appeals apparently. And then we'll deal with that.
Okay, so here's what I don't know then. So I noticed up the entry of our quadro. The objection to the entry of our quadro from Ms. McNiff was the same thing we just did. So
Ms. McNiff, is that accurate? That again, you're objecting to the quadro, but it reflects what the court ruled.
That is accurate.
Okay, then Ms. Thomas, don't say anything else. I don't want you to argue against your position. I will enter that quadro then because it's consistent with what this court ruled, but not. Ms. McNiff is not in agreement with that, but
no,
have to take that to the Court of Appeals.
So there have been two quadros submitted to the court. I just want to make sure that so I submitted one and then Ms. McNiff objected and attached to hers was an alternate one. But frankly, because she used our first and last pages and just changed the middle, it looks like it was mine. I just want to make sure that the court enters the one that is actually ours.
Ms. Thomas, what you'll do is contact my office when we're done, talk to Christy and make sure that the correct one gets sent to me. So the problem we have effectively would have three different orders.
Right.
Make sure the right one gets sent to me and that's the one that I'll enter.
And this will be a final order?
That will be a final order, correct. Okay?
Perfect, thank you.
Thank you. The court will end this matter at 9:24 a.m.
You are not free to go, folks. The court may be done, but I'm not done with you. We have our regular Wordle coming up that I'm going to let you guys in the chat handle while I do a little bit of reading of some petty, but Canadian petty, which means it's like very weirdly polite. and I think you'll enjoy it. So, give me 1 minute. I think I have one more court video actually while I get this sorted out because I'm almost ready. What else what do I have here? Oh, right. We had, okay. I trust in you.
This court's going to call cause number C 242449. This is in the 317th District Court of Jefferson County, Texas. It's in the interest of Yoniel Issei and Nathan Kettles. Ms. Dolores Nash, are you going to be acting as the court's interpreter today?
Yes, sir.
Ms. Nash, please raise your right hand. Ms. Nash, do you solemnly swear that the interpretation that you do for this court today is going to be truthful to the best of your ability?
Yes, sir.
You're not going to mislead the court or the parties in regards to any of the translations from Spanish to English or English to Spanish?
No, I'm not.
Okay, and you're going to do your best to make sure that you're interpreting the best of your ability to make sure that all the information is given to me and to Ms. Torres?
I will do.
Thank you, Ms. Nash. You can put your hand down. The court accepts Ms. Nash as an interpreter. Ms. Nash, please ask Ms. Torres to raise her right hand.
Señora Torres, que levante su mano derecha, por favor.
Ms. Torres, do you solemnly swear the testimony you're about to give
Señora Torres, que usted va a testificar lo que va a decir,
is the truth, the whole truth, and nothing but the truth?
que va a ser la verdad y solamente la verdad?
Sí.
Yes.
Thank you. You can let her know she can put her hand down. All right, Ms.
Puede bajar su-
Alexander, this appears to be an original petition that you filed in December of last year.
Yes, Your Honor.
All right, let's check some service and see if we are where we need to be. Looking at my court file, the court's going to find that Mr. Olaguez was personally served a citation in this case out of state on February 23rd of 2023. That citation was returning on file with the district clerk's office on March 13th, 2023. He has not filed an answer at this time. Court's going to find that notice was sent to Mr. Olaguez out of state. He's not here. He's going to go forward with a default. All right. Did you file a first amended?
I was just about to bring that to your attention, Judge. Yes, we filed a first amended to include paternity language for the oldest child. And we did send that
Okay.
to the address that we have.
Hold on 1 second. I will take a look at that as well. Court is going to introduce on its own motion proof to show that Mr. Perez Olaguez was sent. This is the first amended original petition by certified mail. It was sent to the same address for which he was served. This appears to have been done on May the 5th, and therefore, thought you had to have it on file for, is it 30 days or 10 days?
I think it's only 10 days. I don't know that there's a.
Yeah, there's definitely, the first amendment has to be done 30, so many days before trial.
Is it?
Permiso, Yonael, le estoy hablando por teléfono. Ya mismo voy. Cuando termine de hablar, yo los cambio.
Ms. Nash, ask Ms. Torres to hold on 1 second. We're looking up some law.
Señora Torres, que se espere tantito. Están buscando algo de la ley.
Sí, ok.
Just be patient. I just did a bunch of research for a friend of mine in another state, so I'm getting my dates mixed up.
Judge, from what I'm looking at, Texas Rule of Civil Procedure 63 says 7 days
There
before the
you go.
hearing.
Huh? Like I say, it's been a while. All right, you got it on file for plenty of time. You sent it plenty of time, so you're good to go.
Thank you, Judge. May I proceed?
You may.
The state will call Miss Quiros Torres. Ms. Torres, Quiros, what is your full name?
Señora Quiros Torres, por favor, diga su nombre completo.
Sí, Jesselyn Nicole Quiros Torres.
Jesselyn Nicole Quiros Torres.
What are the names of the children before the court today?
¿Cuáles son los nombres de los niños de esta corte para esta orden?
Isaí Pérez Quiros, Jonael Pérez
Isaí.
Quiros, Nathan Pérez Quiros.
What is
She said
Janelle?
Isaí.
Oh, my apologies.
Okay. I'm sorry. Go ahead.
What is Janelle's date of birth?
¿Cuál es la fecha de nacimiento de Jonael?
Diciembre 10 del 2018.
She said December 10th of 2018.
And what is the date of birth for Isaac?
Y la fecha de nacimiento del niño Isaí.
Octubre 12 del 2019.
She said October the 12th of 2019.
And the date of birth for Nathan?
Y la fecha de nacimiento de Nathan.
Marzo 22 del 2021.
March 22nd of 2021.
Who is the father of the three children?
¿Quién es el papá de los tres niños?
Jesús Israel Pérez Olagues.
Jesús Israel Pérez Olagues.
And are you currently married to him?
¿Estás corrientemente casado con él?
Sí.
Yes.
When did you get married?
¿Cuándo te casaste? ¿Cuándo se casaron?
Mayo 19 de 2019. Disculpa, mayo 11 de 2019.
She said May 11th of 2019.
Okay. Janelle was born before the marriage, is that correct?
Jonael nació antes del matrimonio.
Sí.
Yes.
Could there be any other man who could be the father of Janelle other than Jesus?
¿Podría haber alguien más, aparte del Señor Jesús, que sea el papá de Jonael?
No.
No.
Were you married to anyone else at that time?
¿Durante ese tiempo estabas casada con alguien más?
No.
No.
Are you asking the court to find that Jesus Perez is the biological father of Janelle?
¿Estás pidiendo que se ponga de que el Señor Jesús Pérez Olagues es el papá de Jonael?
Sí.
Yes.
Okay. What state does dad live in?
¿En qué estado vive el papá?
En Arkansas.
He said in Arkansas.
And when did he move there?
¿Cuándo se movió allá?
Un día antes del Día de Padres del año pasado.
She said one day before Father's Day, June of 2022.
Okay. Did you and dad and the children all live together in Texas?
¿Tú, los niños y el papá vivían juntos en el estado de Texas?
Sí.
Yes.
When did you all move to Texas?
¿Cuándo se cambiaron para Texas?
Marzo 3 del 2020.
March the 3rd of 2020.
Okay. And you lived together as a family from March of 2020 until you separated. Is that correct?
Y vivían juntos como familia desde marzo 3, 2020 hasta que se separaron?
Sí.
Yes.
When did you separate?
¿Cuándo se separaron?
En abril 4 del 2022.
April the 4th of 2022.
Okay. Do you have any concerns as to any family violence between you and dad?
¿Tienes alguna preocupación sobre violencia doméstica entre tú y el papá?
Sí.
Yes.
And what are those concerns?
¿Cuáles son tus preocupaciones?
No quiero que sepa dónde yo vivo porque él es muy impulsivo y no quiero que venga a buscarme problemas aquí.
She says that she does not want him to know where she lives because he's very aggressive and impulsive, and she doesn't want him to go to her home and disrupt her peace.
Has there been any other issues with family violence in the last 2 years?
En los últimos 2 años, ¿ha habido problemas con violencia doméstica?
Sí hubo violencia doméstica, pero ahora es violencia verbal.
She said previously it was physical abuse and family violence, but now it's just verbal abuse.
Okay. When was the last time there was any physical abuse?
¿Cuándo fue la última vez que hubo abuso físico?
Hace aproximadamente como 2 años, un poquito más de 2 años.
She said approximately 2 years, maybe a little bit more than 2 years.
Did you ever file any police reports?
¿Alguna vez hablaste con la policía?
Sí.
Yes.
Was that in Texas or in another state?
¿Fue aquí en Texas o en otro estado?
En Arkansas, él fue a la cárcel y fuimos ambos a la cárcel. Y aquí en Texas hablé con la policía y en casa de mi papá tiene una orden de no traspasen.
She says that in Arkansas, they both went to jail. And in Texas, she called the police and he has an order of no contact with her other children.
When was that order done?
¿Cuándo fue esa orden en Texas?
Antes de que él se fuera al estado de Arkansas.
She said right before he moved to Arkansas.
How long was that good for?
¿Cuánto tiempo era buena esa orden de no acercarse?
Disculpa.
¿Cuánto tiempo era para esa orden de no acercarse a ustedes?
Bueno, no dice, me dieron un papel, pero en el papel no dice hasta qué fecha se vence.
She says she was given a paper, but it doesn't specify a date of when it expires.
Buenos días.
Who takes care of the children on a day-to-day basis?
¿Quién cuida a los niños día a día?
Yo.
Her.
Who makes all the major decisions for the children?
¿Quién hace todas las decisiones mayores para los niños?
Yo.
Hold on. And listen, I failed Spanish too, guys, but she's not saying her, she's saying I. Isn't yo I or me? Isn't the translation meant to be the words, not the intent? Like, am I wrong? Shouldn't she be saying I, me, instead of her? I don't know.
What was that? I'm assuming she said
She
her.
said her.
Okay.
Yes.
When was the last time Dad had any visits with the children?
¿Cuándo fue la última vez que el papá tuvo visitación con los niños?
En marzo, creo que fue el 20. Sí, como el 22 de marzo de este año.
She said March the 20th or March the 22th of this year.
Okay.
The 22nd?
Does dad come to Texas to visit the children?
¿El papá viene a Texas a visitar a los niños?
Solo vino este año una vez.
He's only came this year one time.
Okay, how does he visit the children other times?
¿Cómo visita a los niños de las otras veces?
Porque yo los he llevado al estado de Arkansas para que él comparta con los niños.
Because she takes the children to Arkansas so that they can see their father.
When was the last time she took the children to Arkansas?
¿Cuándo fue la última vez que llevaste a los niños a Arkansas?
En diciembre.
In December.
Okay. When you take the children, does he have the children on his own?
Cuando llevas a los niños, ¿él tiene el tiempo con sus niños solo?
Sí.
Yes.
Do you have any concerns as to any? Do you have any concerns as to any visits that dad would have with the children?
¿Tienes alguna preocupación de que los niños visiten con su papá?
No.
No.
Okay. So you would be okay with what we call a standard possession order, which I did describe that to you. You're okay with that?
¿Estás bien con lo que permite la ley de Texas, que ella te lo explicó anteriormente?
Sí.
Yes.
Where would you like the pickup and drop off of the children to be done at?
¿Dónde quieres que los niños, dónde quieres que recojan a los niños y regresen a los niños?
Lo va a recoger en casa de mi papá. Y si es aquí en el estado, si yo estoy aquí en el estado de Texas, en casa de mi papá.
She said if she brings him to Arkansas in her mother's house because she lives in Arkansas, if he comes to Texas in her father's house because he lives in Texas.
Okay. How are the children covered with Medicaid? How are the children covered with government, with health insurance?
¿Qué clase de aseguranza tienen los niños?
Medicaid.
Medicaid.
Okay. How many other children does dad have other than the 3 before the court?
¿El papá tiene otros niños aparte de los 3 que tienes tú?
Sí.
Yes.
How many other children does he have?
¿Cuántos niños tiene más? ¿Cuántos niños tiene aparte de los tuyos?
Una.
One.
Okay, and that is his biological child under the age of 18, correct?
Y el niño este es un niño menor de 18 años, es biológicamente del señor.
Sí.
Yes.
Do you know if dad works?
¿Sabes si el papá trabaja?
No.
Okay. What kind of work did he do when you both lived together?
Hold on. No, he does. No, you don't know, or no, he doesn't. I don't know.
¿Qué trabajo hacía él cuando vivían juntos?
Trabajaba de roofing.
He used to be a roofer.
Okay. And how much did he make a week when you were together?
Más o menos, ¿cuánto es lo que ganaba por semana cuando vivían juntos?
Como $1,000 a la semana.
She said about $1,000 per week.
Okay. And how long had he been a roofer when you were living
¿Por
together?
cuánto tiempo él era rufero cuando vivían juntos?
Bueno, yo duré con él 6 años y los 6 años él trabajó de rufero.
She said they were together for 6 years, and during that time, he worked as a roofer.
Do you know if he was, what kind of work was he doing when he first separated from you before he moved to Arkansas?
¿Qué clase de trabajo hacía o sabes de qué hacía cuando se cambió para Arkansas?
Él cortaba árboles.
She says that he was cutting trees.
Okay. Have you received any support in cash from dad since you separated?
¿Has recibido asistencia de manutención del papá desde que se separaron?
Solo recibía como $40 cada aproximadamente 2 semanas,
She said she was getting $40.
pero hace 2 meses,
Okay.
disculpa, hace como 2 meses no recibo dinero.
Okay, she says that she was receiving $40 every 2 weeks, but for the last 2 months, she has not received anything.
Okay. Are you asking for back child support or just child support moving forward?
¿Estás pidiendo manutención retroactiva desde que se separaron o nada más de hoy en adelante?
No, yo estoy pidiendo manutención retroactiva.
She wants back child support.
And you want that from the time that you separated?
¿Y estás pidiéndolo desde que se separaron?
Sí.
Yes.
And no further questions, Your Honor.
Go ahead, next witness.
And no further witnesses, Your Honor.
Ms. Torres, you said that you had an order of protection?
Señora Torres, tú dices que tienes una orden de protección.
Tengo una orden de no trespassing en casa de mi papá.
Oh, she said that it's an order of no trespassing.
Okay. So that's not an order of protection. And you said that both you and Mr. Perez Olguez went to jail in Arkansas?
Y dices que tú y el señor Pérez, los dos fueron a la cárcel en Arkansas?
Sí.
Yes.
Ms. Torres, did you get charged with a crime in Arkansas?
Y a ti te pusieron algo, o sea, te demandaron y tuviste por alguna razón, ¿por qué?
O porque habíamos discutido, tuvimos una discusión fuerte y él me había pegado. Entonces yo como que me defendí y lo saqué en un apartamento, lo corrí del departamento y él llamó a la policía.
She said that they had a heated argument and it was physical and she kicked him out of the house and that's why she ended up going to jail.
Did she get convicted of a crime?
Y te dieron, o sea, te dieron por alguna culpa, o sea, te dijeron que iba a sacarse por alguna culpa.
No, solo me arrestaron y pasé la noche en la cárcel y ya me sacaron al otro día temprano.
She said that she was arrested, she went to jail overnight and she got out the next morning.
Did she pay a fine?
¿Tuviste que pagar algo?
Mi papá pagó, creo que fueron $300.
She said that her dad paid $300.
Okay. Disturbing the peace.
Dice que destruyendo la paz.
Okay.
She said, okay.
Did Mr. Perez Olguez go to jail in Texas?
El señor Pérez Olagues fue a cárcel en el estado de Texas.
No.
No.
Anything further from the state?
Nothing further from the state, Your Honor.
Ms. Torres, do you have any other information that you think I need to know about this case before I make a ruling?
Señora Torres, ¿tienes alguna cosa más que agregar antes de que él decida lo que va a hacer en la orden?
No.
No.
All right, here we go. Court's going to find the court has jurisdiction in this case. The court's going to find that Mr. Perez Olguez is the biological and legal father of the child Joni L. I'm going to find that it is not in the children's best interest to name the parties as sole managed conservators or as joint managed conservators. Ms. Torres will be the sole managed conservator, and Mr. Perez Olguez will be the possessory conservator. As per Ms. Torres's request, he will be granted standard possession. The request for non-disclosure in this case is denied. There will be no domicile restriction in this case. I will find that Texas does have jurisdiction over Mr. Perez Olaguez under the long arm statute. I'll order Ms. Torres to maintain the health insurance that she has on the children. And Mr. Perez Olaguez is going to pay child support as per a minimum wage presumption, there being no evidence of wage information since they separated. Therefore, based on my findings, I'll find that Mr. Perez Olaguez's child support will be $310 per month. I did give him credit for one other dependent. The medical support will be $25 a month. I'll grant retroactive child support, but he has paid some money. I deducted that from my retro calculation and find that the retroactive child support in this case will be $3,084. He'll pay that back at a rate of $30 a month. All payments will begin June the 1st of 2023. Court costs by Mr. Perez Olaguez, and that'll be due by December 31st of 2023. Ms. Alexander, did the state of Texas hear all the terms and conditions of my court order?
Just one clarification, pick up and drop off, or is that just going to be understanding possession order?
At her own.
Okay. Nothing else, Judge?
All right, Ms. Nash, you ready?
I'm ready. I got it all written down.
All right, here we go. Tell Ms. Torres that I'm naming him as the father of Joniel.
Dice que lo está poniendo que el señor Jesús Israel Pérez Olgáez es el papá de Jonael.
Ms. Torres will be the sole managing conservator. Mr. Perez Olaguez will be the possessory conservator.
Dices que tú vas a tener derecho de decidir dónde van a vivir los niños y el papá nada más tiene derecho de visitar.
I gave him weekend visits as per her request.
Y le dio los fines de semana de visitación como tú pidiste.
Okay.
I did not hear sufficient evidence to grant the request for non-disclosure. There has to be evidence of family violence and a threat of future family violence.
Dice que no aceptó de no poner tu dirección en los papeles de la orden porque tiene que ser violencia doméstica, física o que va a haber problemas más adelante y él no piensa que debe de quitar tu dirección de los papeles.
Okay.
There is no domicile restriction in this case, so Ms. Torres is free to move about the country. She is required, however, to notify Mr. Perez Olaguez by mail when she's going to move and where she's going to be moving to.
Dice que no va a restrictir que no te puedes mover tú para donde quieras. Tú puedes cambiarte de dirección donde quieras o a otro estado como quieras, pero sí tienes que avisarle al papá por correo donde te cambiaste.
Okay.
I've set his child support at $310 a month and his medical support at $25 a month.
Le puso manutención de 310 al mes y 25 al mes para la aseguranza.
And I've ordered Ms. Torres to keep the children on Medicaid for as long as they qualify.
Y dice que tú puedes mantener tu aseguranza de Medicaid mientras tú calificas.
I did order retroactive child support in the amount of $3,084.
Dice que sí pidió que te dé manutención retroactiva de $3,084 al mes.
And Mr. Perez Olaguez is going to have to pay that back at a rate of $30 a month.
Disculpa, es $3,084 total y él tiene que pagar 30 al mes hasta que pague todo.
All payments in this case began yesterday.
Y todos estos pagos empiezan ayer.
Mr. Perez Olaguez is responsible for court costs, but I gave him until December 31st of this year to pay.
Y el señor tiene que pagar los gastos de la corte, pero le va a dar hasta diciembre de este año para que los pague.
Okay.
Ms. Alexander is going to prepare a court order for me. If it matches what I said here today, I'm going to sign it, get it back to them. Then they're going to make copies of it, mail it to everybody, including Ms. Torres.
Dice que la abogada Alexander va a hacer la orden. Mientras tenga todo lo que el juez acaba de decir, él la va a firmar y luego les va a mandar una copia a cada persona.
Okay.
Okay.
I thank you for being here today, Ms. Torres. You're free to go.
Muchas gracias por estar aquí y puede colgar.
Okay, folks. So what we are going to do here, the intermission, um, shortly. I am going to be coming back in just a few minutes with a totally different stream. We won't be watching court. We will be playing a word game in the chat while I read you some petty, funny stories from small town Canada. And I hope you enjoy it. I can't make the new stream until I'm out of this one. Otherwise, I would have already done that, but I can't. So what I'm going to do is end this stream in about as soon as I'm finished talking. Then I am going to quickly create a new one, hop into the chat and post it for y'all, and then hope that some of you migrate over there if you care and want to. It will be a lot more scattered, I imagine. This is sort of our Friday night thing. But, yeah. Anyways, okay. I said about. Oh, this is, if you want to hear me say funny Canadian stuff, this is going to be the night for you because we are going to be reading it's not my town, it's a town 2 hours away from me on my island, and their local like newspaper has a section in it that posts weekly called Beefs and Bouquets. And you can write, I don't know if you've ever heard of Beefs and Bouquets, but you can write in and say what's bothering you, and that would be a beef, or what has been nice, and that would be a bouquet. And they compile them and you read them. There's maybe like sometimes 10, sometimes 20, sometimes more. And first of all, we're going back to the beginning, early days, and the most petty shit ever happens over these things. Like people are like beef to the beef to the beef or to the this, that. It's great. I used to look forward to them every week. So I'm excited to share these with you. I'll be reading them out loud while y'all can see the big wordle that will be popped up. So if that is something that interests you, then make sure you come about later. It's not going to be that much later, folks. I'm talking about in like 5 minutes at 9 p.m. Pacific time. I guess that's midnight. Whatever. We don't sleep shame here. Anyways, I just want to thank you very much for being here with me tonight, enjoying the court as we always do. I've got lots of fun stuff coming. So, I'll end this, start the new one. See you soon.